John, where are you going? Okay. Okay, folks, if everyone could take a seat or
Mine works. Help.
That was spelled out.
Yeah.
Mine works.
Turn them off and see what happens.
podium.
That's just as good.
I don't know. I got nothing.
Those two.
Everybody works.
Oh, mine working. Okay.
Yeah.
There we go.
I think we're in business.
Yeah, it's all under theirs. If you
I didn't
kick
touch
over
it.
the
I didn't
wrong
touch it.
one. I don't know. That's
Okay, let's try that again. Calling to order the Malibu Planning Commission regular scheduled meeting for Monday, August 7th. May we have a roll call, please?
Commissioner Jennings. Here. Commissioner Mazza.
Here.
Commissioner Euring.
Here.
Vice Chair Marks.
Here.
Chair Pearson.
Here.
You have a quorum.
Thank you. Can Mr. Marks, would you lead us in the Pledge of Allegiance? Thank you, Vice Chair.
No problem.
Can I have a motion on approving the agenda?
I'd make a motion to approve the agenda. Make a motion to approve the agenda, continuing item 5B to a date uncertain, 5D to 8/21, and 5C to September 5th.
Do I have a second on this?
I second.
Okay, all in favor?
Aye.
Aye.
I'm abstaining because I'm recused on item 5C.
Okay, thank you. Can I have a report on the posting of the agenda?
The agenda for this meeting was properly posted on July 28th, 2017.
Thank you, Kathleen, very appreciated. Written and oral communications from the public and items not on the agenda. Do we have any speaker slips? We do. Okay, we got a few. First up, we have Norm Haney, will be followed by Fred Gaines and then Pamela Ulick. There you go. Hi, Norm.
Good evening, Planning Commissioners. This is an exciting time to speak to you. Basically, I want to talk about the total development square footage structural size chart. When the city got their approval to incorporate, they had a full year to make a determination as to how they wanted to zone properties and how they wanted to come up with the basic size of what they felt was considered consistent with the character of rural residential. So when they finally incorporated, it took them 2 years to get their act together, and they came up with the Malibu Municipal Code. And in that code, they wanted to tell people exactly what they could expect when they filed an application for a residential project. So they established height standards, setback standards, basement standards, and the list goes on and on. And one of the standards was how large a house you could build and still be consistent with what they defined as rural residential. These standards were followed for 24 years. Basically, they were also codified by the California Coastal Commission when they approved the local coastal program. And in that, I'll just read one segment. It says, for lots up to 1/2 acre, total square footage shall be 17.7% of the lot area plus 1,000 square feet. And it goes on. The important word here is shall. Basically, the planning department was told what was consistent with the character basically defined as rural residential. And that's exactly what they did. You couldn't build over that number that was specified, but you could build under it, even though it says shall. Lately, the City Council and the Planning Commission has put that into question. The envelope that was supported by some of the most conservative people in the city of Malibu put together, Carolyn Van Horn, Walt Keller, I think Jeff was one of the city council members at that time as well. So when you go to change it, when you change this envelope, you're basically telling people you have no idea what you can build, and good luck. So spend the money on geology, on architecture, and when you come before us, we may or may not approve it. Thank you.
Thank you very much, Norm. Fred Gaines, and you have 4 minutes because I see Jake back there.
Thank you very much, Mr. Chairman, honorable members. Fred Gaines of the Law Office of Gaines and Stacy. I'm here tonight on behalf of 180 PCH LLC. They're the owners of 33386 and 33398 PCH. That's the property near Decker Canyon with the concrete driveway, S driveway that goes down to the beach lots, if you know which one I'm talking about. My clients made an application. I'm here tonight to ask for your help. My clients made an application for homes on those lots. There's actually 3 lots. They're asking for 2 homes in November of 2014. Went through the process of all the various departments. By the end of 2015, a year later, an issue was raised regarding the access. The neighbor, one of the neighbors who lives along that same road, had complained that the access was not correct. And in fact, there's litigation ongoing between the parties regarding that. In the meantime, we have worked with every department that we've been asked for. We have provided not only the actual access easement agreement, there actually is an agreement that provides for the access, but the title insurance policy, a survey, the actual purchase sale agreement, which talks about the access. That's the purchase sale agreement by this neighbor who's now suing, who bought from the person who created the access. The fire department access plan that's been approved. And then from the litigation, we have both interrogatory, we have discovery response and transcripts where they admit that they're not making any claim on the access. Despite all of that, and we've had lengthy discussions with the city attorney, with city planning, all of which was leading us to believe that we were going to be scheduled for hearing. Other than that, we're ready to be scheduled for hearing at the Planning Commission on this application from 2014. We just received, July 31st, from the Public Works Department, a basically 1-sentence, 2-sentence response saying, the applicant shall provide legal access for the parcels. So we're stuck, and we've said to the city attorney and planning, just put us forward. Either put a condition of approval on that says you need to prove the following, or you need the following document, or recommend denial. if that's what you want to do. But let's get us forward. You can't let one complaining neighbor, imagine if one complaining neighbor claiming they have an access claim could hold up every project in the city of Malibu. And as long as someone said, well, I don't think they have access, even though you're giving all the documents and everything else, that they'd be able to do that. And so we are asking, this, I know it's an unusual request, but we want to come forward and have a hearing on this case. And we've been through the process. You can confirm that all the other departments have done their reviews and provided their sign-offs. We've been told that planning can write a staff report other than this one issue from, now it's the Public Works Department that has a question on this, and after all this sends us this without telling us exactly what it is that is insufficient with what we're doing. So that's really why we're here. If you were willing or interested to inquire to staff or to request that the matter be set for hearing, we would greatly appreciate it. We're deserving of that at this point in time, and I appreciate you taking the time to listen to these comments. Thank you very much.
Okay, thank you, Fred. Pamela?
Good evening, Kathleen. Before I start, I think I have one additional minute from Nick Shar. I don't think I'll need it, but just, Nick, did you fill out the paperwork? Do you want him to fill it out?
Yeah, go ahead. If we don't find it, we'll have him fill out another one.
He's right here.
Yeah, I see him.
Okay. Good evening. Thank you so much. First, I want to thank the Planning Commission for being here and taking time out of your busy lives and your families' lives and really sacrificing every Monday or twice a month you meet? So at least, and all the other meetings. So we're grateful for you and thank all the people here. I'm going to tell you a story. Once upon a time, there was a girl and she met an amazing boy. And they had a lot in common. They laughed, they had fun, they fell in love. They got married. They were really happy and they were in Malibu. And they had one bedroom and that was just fine. They both worked many hours a week and they were happy. And then all of a sudden, after they got married, they found out they were going to have a little miracle, a little baby. So they had their little gorgeous girl and they were happy. But the one bedroom started to get a little tight. They kept going to work, they kept doing what they had to do, and then lo and behold, about another year and a half, guess what? They had another little miracle. They had a little boy. And they were living in one bedroom. And it was good, life was good, but it started to get really cramped with two little babies. And so they decided to hire an architect, Mr. Ed. I'll just call him Mr. Ed. And Mr. Ed knows the laws, knows the Malibu City planning codes, and he designed a house, and it was an odd house. It was a square house, it was a glass house, but it was a good house. And they looked up all the rules, they complied with all the regulations, so Mr. Ed submitted the plans to the city of Malibu, and life was good. And they thought, we followed the law. We're not going to have a problem with our house, with our one-bedroom house, making it the 2 more bedrooms for the kids and another master bedroom for the parents. And lo and behold, the neighbors complained, and it was sad. And they had a hearing at the Planning Commission, and the neighbors came to complain, even though their house was much bigger, and it didn't block any of their ocean view, but they didn't like the house, and so they complained. So after that, it went to the Planning Commission, then it was appealed to the City Council because they didn't like the decision of the Planning Commission, which was to follow and uphold the law. And so this neighbor complained, and then they had another hearing. 4 years later, after this family of 4 was living in one bedroom, after all these meetings, they came to the City Council meeting, the final day. Here we are. We're going to hopefully, within the law, get our plans. Well, they decided to be good neighbors, and they worked with their neighbors. They changed the structure. They lowered it. They even put a big hole in the house because that's what the neighbors wanted. And that night, at the City of Malibu meeting, they took a break and they decided to change their plans, which were all within the law, so their neighbors would be happy. Life was good. And another couple years, guess what happened? The neighbors left. So we had, the boy and the girl had to spend extra money, change all their plans, put a hole in their wall, even though they didn't want the hole in the wall. But now they have their house. So I'm just telling you this because it's not a fairy tale. It happens. It's not right. And I try and teach my kids to abide the law. And when you abide the law, good things should happen to you. You should be rewarded and not punished. And I hope and pray tonight that you remember that little story, because you're going to be asked to uphold laws. And I hope you will dignify the laws that were written. If you don't like the laws, that's good too. Run for the city and change the laws. So thank you for your time, and I look forward to seeing you later.
Thank you. I appreciate your input. Is there anyone else who wishes to address us on an item not on the calendar tonight? Okay, seeing nobody, bring it back up this way. Commissioners, I'll start with Mr. Jennings. Comments?
Yeah, but with Mr. Gaines's issue, I have to keep repeating this because everybody thinks that we have the power to direct staff to do whatever we want, and we don't. We're not in the chain of command. The chain of command over the planning department runs up to the city manager, and from the city council to the city manager. I'm sympathetic that I can understand why you feel so frustrated about being able to move the matter forward, but it's not something that we can direct. Maybe Bonnie will have some comments on it, but that's the status of it.
Anything else, Jeff? Good? No. Okay. Steve?
No.
Nothing? Mr. Mazza?
Yes. On Fred Gaines's item, I hope it's proper for us to just ask for the staff to come back at the next meeting and give us a brief report on, and I'm doing this because I don't necessarily take everything everybody says at the podium as gospel. So I'd just like to have some feedback on whether or not his application is moving along and how it stands. If we can have consensus on that, I appreciate it. The other thing I want to mention is Pam's story. And I think one thing people must realize is we are not charged with or actually allowed to consider the vote of the neighbors. Okay, it's not a popularity contest. Jeff has mentioned city started out with everybody filling the room and they got their house approved, and everybody not coming and they didn't get their house approved. Well, that's changed, and we look at what the LIP and the MMC says. We look at how we're directed by the city council, because we don't make policy. And if you were at the last meeting, we had a staff report on where we stand on this. We don't know what we call it, but neighborhood standards, neighborhood character. So I just want people to understand, if you fill this room and everybody was cheering or booing for some project, we're not supposed to consider that. That's it.
Okay. Vice Chair Marks?
I think it's already been said, but I did want to hear what we can do for the situation that Fred described. Otherwise, I think Pam's story will be talking more of that through with specifics. So.
Okay. For myself, first, I discovered I won't be here next meeting. So Vice Chair will take over. Sorry about that last minute change of plans. I'm going to be gone next meeting, yes, unexpectedly. Beyond that, I just want to, Mr. Mazza went over it, but I generally at meetings talk about the process here, and tonight is certainly a good night to do that. So you already heard what we're charged with doing, which I like to go over. We're not allowed to consider who's good people, who's bad people. We've had items come before us where people submitted evidence the guy was an international drug dealer and a murderer. That we don't get to decide on that. 50-year residents of Malibu, we don't get to decide on that. So when a lot of stuff comes in from the neighbors, like John said, yeah, technically we're not supposed to really, that's not part of our decision process. It's not the way we're supposed to. We're supposed to look at the codes and make the findings. But I'll go a little more off script on that. But in a way, it does matter because the rules are written, and one reason we're here is the rules are not as clear as we'd like them to be. I don't think anyone would, I think everyone would like them to be more clear. And there is gray areas, and it is confusing. And we are doing our best, but it's challenging at times. The language of the code can be challenging. The history of the code, how it's been interpreted, is challenging. Changes made by city council, challenging, really challenging. So we're up here doing our best, but when the neighborhood does show up, it does actually tell us there's a lot of interest in the project. And as human beings, I notice we give it a different look. It's some projects I think would just sail through if neighbors didn't show up and tell us stuff we didn't know. So that can be important. It is evidence that we are here and we're supposed to listen with open ears and open minds to evidence here. We don't come here with our decisions made up. That's wrong. It's specifically, we're not supposed to do that. So yeah, there is actually a side where people showing up and saying they support a project or not does make a difference because it's new evidence that we have to take in. With that said, our personal feelings on something shouldn't factor in. Just because we like or dislike architecture of a certain house or the size of a project or anything about it, if it fits the codes, we're supposed to approve it. So it leaves us in a position where we'll often, and I know this feeling, we have to vote yes or no for something that we actually feel the other way. Because personally, it's not my cup of tea, or personally I love it, but the codes don't allow certain kinds of construction in Malibu that I think would be amazing and we should. So that part gets interesting too. And then we're making decisions based on the evidence presented in the staff reports, from the public, from the applicant, and doing the best we can. If you don't like it, which is, fairly common, there's recourse and you can appeal to the city council. You have 10 days and to do that, and you can be heard by them. And they are a different decision-making body, so that option is available. So with that said, I also, Fred, have no idea what project you were talking about, but certainly thank you for speaking up. And Norm and Pam, thank you both on your stories. All these things they're important and they're parts of it, and right now is an interesting time at the Planning Commission. I am looking for direction, I hope is coming from City Council on some issues that are really, maybe they seem black and white for where some people are sitting, but when you're sitting up here, they don't seem so black and white, at least not to me. So with that said, let's move forward. And Bonnie?
Thank you, Chair Pearson. I wanted to make two quick announcements. Actually, it's one announcement, two items. Speaking of direction from City Council, staff is going to be bringing to City Council on August 28th the neighborhood character issue to try to elicit some better direction on how they want us to handle that. And I don't know if we'll be looking at a code amendment or just some policy or what, but we're going to be doing that on August 28th. And the other item that might be of interest to you and the public is that the LCP amendment addressing CDP expiration, we'll be bringing that on the same night, August 28th. With respect to the project Mr. Gaines is representing, we've been working closely with the applicant and the Public Works Department. There are some issues with access that he referenced with a neighbor. We are working on that issue as well. If you want more discussion about that at the next meeting, I can provide more of an update. I think we will have more of an update at that time. This is ongoing. It's a matter of bringing forward to you a complete application, and as you know, that sometimes gets complicated. I don't know if you want to hear from an applicant every time they have a concern with the way their application is being processed. That's my only reluctance about, I'm happy to discuss it with anybody, but I don't know how you want to handle that going forward.
Bonnie, one of the factors they mentioned was, and this has come up several times, is conditioning a project on an unresolved question. Like, for example, we condition a shopping center and say, you figure out how to fix the corner. Is that something that can be used to speed up some of these things?
That's a complicated question. I mean, I hate to say it, it's everybody's least favorite thing, a case-by-case basis, because we don't want to set projects up for failure and have, extensions and things like that. If there are some kind of foundational issues that aren't resolved, it doesn't seem to make sense to bring them to you and then have these projects that can't really move forward until there's something major that needs to still be resolved. On the other hand, there may be situations where it's more of a minor issue that can be just more realistic to think it can be addressed.
You also need to have enough information presented for you to make the actual findings. Just saying, I would approve this if XYZ happens isn't an appropriate way to approve a project. You need to be able to see the facts that they have made that you can make the findings needed to approve a project.
Well, just a general question, and I'll drop it, is it's my understanding under California law, you can't landlock a property. So there is always access. Is that correct?
Well, but where that access would be and what it would consist of could depend on, what a court finds or what the history of the project is or things along those lines. But in general, there should be some access to every property.
Okay, thank you.
Trevor, did you have anything else to add?
No, thank you.
Okay, well then let's move forward. We're going to go to the consent calendar. Does anyone wish to pull an item from the consent calendar?
I'd like to pull 3B1 and 3B2.
Okay, 3B1 and 3B2 are... Okay, so we're pulling absolutely everything. So we are not going to do anything on the consent calendar, except we're going to pull each item here. So let's start with 3A1, Local Coastal Program Amendment 16-003, an application to change the LCP land use and zoning designations for 4 contiguous parcels from public open space and rural residential 40 acre to rural residential 20 acre. Can we have
I was going to ask Commissioner Jennings if you're looking for a full report or...
Let me give you the scope of my concern.
Thank you.
This was the matter where the issue came down to the question of not only had there not been a determination of whether the open space requirements survived the foreclosure, but we had no guidance from the city attorney's office one way or the other as to whether it had or not. And as far as I'm concerned, that was the basis on which I voted to send it to the city council. We have a resolution in our packet, which, as good planners and city attorneys do, is an effort to bulletproof the thing by making all the negative findings that really never were discussed in the course of an examination of this. The real reason we sent it back wasn't because the residential development that is designated environmentally sensitive habitat or anything like that. Any of the conclusions that are in the resolution, except for the last one, which was 6. The applicant provided insufficient evidence that the open space deed restriction was removed as part of the property transfer. It seems to me that what you end up getting into is a situation where I'm stumbling here because I'm complaining about something which isn't really an issue in this particular case, because this is going to go to the city council. The city council is going to decide on that issue. But from time to time, we do get these resolutions which are basically an attempt to bulletproof by providing, okay, here's the reason why it was made, and there was also this reason, and also this reason, and also this reason. And none of that was really applicable in this situation. So my preference would be simply to have item 6 of the findings be sustained and all the rest of them just stricken.
Question?
Do any of the other sections need modification, though? Or just section 4, bullets 1 through 5?
We never decided yay or nay on them, so if we take them out, does that mean we approve them? Because we didn't really even,
No, we never really
we
considered.
never really went there. did
Yeah,
we?
and so it seems to me that those findings, well, they backstop it. Trevor, you look like you have something you want to comment on.
Quick question, Trevor. These were in the staff report though, correct? So we did
Yes, I believe
go
they
through
were.
the staff report.
So if the motion would be to approve the resolution, but strike 1, 2, 3, 4, 5.
From section 4.
Okay. I think there's a comment, public comment also.
Well, my question would be, oh,
Do you want to open the public hearing before you?
yeah.
Okay. Oh, we got a couple. Okay, then let's go right to the public hearing on this. I'm going to open the public hearing. We have Fred Gaines and then Norm Haney. Oh, yes?
My understanding of where we are procedurally on this is the only issue is, does this resolution reflect what we decided at the last hearing? We're not going to rehear the whole thing again. It's just that's the simple question.
That's absolutely correct.
Completely
It's-
agree,
It's
yes.
not about change. You can't change what happened. It's just whether that memorialize what happened at the last meeting.
Fred?
And I agree too. I like to say in these circumstances, we're in heated agreement. But Fred Gaines of Gaines and Stacy on behalf of the applicant. My point of coming tonight was that these findings were issues that were not discussed. I mean, I could go into each paragraph as to why I don't think it's applicable, but these were not things that really were involved at all in our hearing. If we were going to have a hearing about these things, then we would make arguments, and I could tell you why I think these apply or don't apply, and we can look at the facts. But this was never done. The only thing I agree with the comments of Commissioner Jennings, and that really was the purpose. I didn't think the resolution appropriately reflected what was done at the hearing. I would also disagree, however, on number 6, at least the way it's stated, because what you're preparing to leave in is that the applicant provided insufficient evidence that the open space restriction was removed. And I don't, if you're going to do that, then you should tell us what evidence that we need to put in. But I don't think that's actually correct, because what the applicant provided was the only evidence you have is from the applicant. The applicant gave you that the foreclosure and the bankruptcy documents and letters from 2 different law firms that this had been wiped out. The city attorney has not given you an opinion as to whether that's correct or not correct. We haven't been asked for any additional information on this, and if we are, then I think you should identify what it is. If you want to say that you needed legal guidance and the city attorney wasn't prepared at the time to give you legal guidance as to the correctness, that would be an appropriate finding. But to say that we provided insufficient information, I don't think is correct. And if it is correct, then please identify the information that we need to provide. But with that was the purpose. I didn't think that this resolution accurately reflects. I'm certainly supportive of Commissioner Jennings' motion with those potential amendments. Thank you very much.
Okay, thank you. Norm?
Again, thank you for the opportunity to discuss this item. I agree with Commissioner Jennings as well as Mr. Gaines with regard to the resolution. I think that what was discussed was only one thing, and that was the position that the Planning Commission had, was that their position was insufficient evidence to verify. I will also, though, say that you need to find another category when you decide that 2 private people can make can decide that an area will be open space, and the same 2 people can eliminate it if they want to. But your definition for public open space is that, first of all, it has to be owned by the public. And then the government, some portion of the public entity has to have a stake in it. Has to have, some position where it can't be eliminated simply by two people getting together and say, I'll buy you a drink if you eliminate this deed restriction. And then the public has no say one way or the other. And that's the situation that we have here. Thank you for your time.
Thank you, Norm. Pat Healy?
Not surprisingly, I disagree with Mr. Gaines. I think there was insufficient evidence, and I think that the Coalition for Slow Growth presented enough evidence to indicate that the applicant was mistaken. And so I think you have sufficient evidence. And also, all the environmental findings you made, if they're necessary, I think they have to be put in. If they're not, I'm fine with taking them out. But they were listed in the staff report. Mr. Gaines commented on them in his letter, so you had all that information. I don't know if you have to discuss every single thing at a hearing or not, but I would just like to add that note. Thank you.
Okay, thank you, Pat. Would anyone else like to address the commission on this item? Okay, we're going to close the public hearing. So we don't have any options here, but some interesting stuff came up, Trevor and Bonnie.
I would just add that the reason for including the policies and a statement about consistency or not consistency in the resolution is because they were mentioned in the staff report, and without it just ties together with the idea that if without confirmation of the status of the deed restriction, you couldn't make the findings that the change in designation would be consistent with these policies. But that's the approach that staff was taking with it.
Trevor, the basic gist is they're saying that, or Jeff is saying, and Mr. Gaines is saying that we didn't consider these items, and then also that no other information was there about them. And Pat turned in that much stuff. I mean, my computer was full of it. And Fred Gaines' both lawyers, I believe, legal letters talked about all this stuff. So when we do a resolution, sometimes they're 30 pages long. Are we necessarily, if it's in the staff report, do we have to go over every item when we go through the public hearing? Because we're going to be here forever on every item then, aren't we?
You're correct. You can reference items in the record. The idea is that what you're approving is either the resolution that's presented in the staff report, or in this case, it's been memorialized for you, and so it would now you would be adopting these findings. And the reason that I think that part of Bonnie was referencing to is that the findings you need to make are whether the LCP amendment would be in the conformance with the goals, objectives, and purposes of the LCP. And so I think the logic here from staff is that because there is insufficient evidence that the deed restriction was removed, if the deed restriction is in place, then it's in conflict with these policies. And so policies should be identified as not being consistent with the LCP amendment, which is why you would recommend it not being approved.
Comments?
Well, that's just not the way it's written. I mean, I can understand working around the barn to get there, but that's not the way it's written. And I'm fine with the way the language of 6 as it is, but 6 is the linchpin on the whole thing. And if we have been presented with sufficient evidence, and I think it is the applicant's job to present us with sufficient evidence, if we had been presented with evidence that showed that, then we would have gone through and considered all those other issues, but we didn't. And so I don't see, I think it gives a distorted view of what we did here to include those findings, period.
Would it, if 6 was moved more into the intro in section 4, is not conformance with the goals, objectives, and purposes of the LCP?
Yeah, I think if you said because numbers,
they didn't present
6,
sufficient evidence.
and then because 6 wasn't found, then blah, 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 that works better.
Okay.
Okay, but let me ask you this. I may not have talked about every issue, but I read, on this one, I probably read 400 pages of stuff, and that was in my mind. Is that considered? Or do we have to blurt it out at every meeting?
No, this is what's memorializing what you thought of. So these are, that these were issues that you considered, and that this reflects what you, the findings that you made based on the entire record. That's what this resolution is designed to do. This memorializes what the
So
decision you're making.
Jeff's purported motion will be to move 6 to where?
It would be to, I believe, and at the end of, so you have section 4, you have an introductory paragraph.
And then before 1?
Yeah, before 1, so it's is not.
6 goes before 1 is all we're talking about.
I don't think it's reordering it. I think it would be incorporating it and basically saying, because the applicant provided insufficient evidence that the open space deed restriction was removed as part of the property transfer, I guess we'd probably insert it higher up. It says that the yeah, probably so. That'd probably be the better way to do it. We'd put at the beginning of section 4, because the applicant provided insufficient evidence that the open space deed restriction was removed as part of the property transfer pursuant to LCB section blah, 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 and then read through. So it basically.
And then what would it say about the other items?
It would say basically, because they provided insufficient evidence that the deed restriction was removed, then it's not in conformance with these provisions of the general plan.
But that would be saying it was in conformance if they had provided, and it wasn't.
Your mic.
All we're doing is saying that because that fatal lack appeared, then we make these findings that they're, the 1 through 5. It doesn't say that, it doesn't imply that if the sufficient evidence had been provided that we would have switched around and made those findings the other way. There's no implication of that.
As currently phrased, each of these would provide an independent basis for not recommending approval of the LCP amendment. The way Commissioner Jennings, I believe, is proposing is to say that, saying the reason why you are finding that it's not consistent with that is because of the failure to provide sufficient evidence of the removal of the deed restriction.
But I don't think that's correct.
Okay. Then
because we were presented evidence on all of this stuff.
It's your motion whether you want to.
So when I voted yes or no or whatever it was, that was part of why I voted no. We didn't say the only reason we're going to vote no is because they couldn't come up with a clear revocation of whatever it is. That isn't what we voted on.
Let me make my motion and see if the motion is as Trevor stated it.
I'll second it so we can have a vote and see where we stand on this. Is there any more discussion or questions?
So just how would that phrase again?
So beginning of section 4 would read, because the applicant provided insufficient evidence that the open space deed restriction was removed as part of the property transfer, comma, pursuant to LIP section 19.3.2C, the Planning Commission recommends, and it continues as it's currently written.
Because if it continues, then it says it does not meet the requirements of and is not in conformance with the goals.
Yeah. And then section 6 would be removed, since it'd be moved to the beginning of section 4.
All right, well, can I ask for a roll call on that motion, please?
Commissioner Jennings? Yes. Chair Pearson?
Yes.
Commissioner Mazza?
No.
Commissioner Euring?
Yes.
Vice Chair Marks?
Yes.
Motion carries.
We're moving on to 3B1, the approval of minutes. John, I believe you pulled that.
Yeah, there's no reason for a staff report, but let's see here. Page 5 of 10. Wait.
Which meeting are we looking at?
Yeah, I got to figure that out. 724.
Okay.
That's why I couldn't find it. On 5 of 10, the motion, at the bottom of the page, it says we are granting a 2-year extension. And when I went back and looked at the the proposed resolution and the tape, it was a 1-year extension. So I don't know what got signed as far as the resolution went.
We'll double check
yeah,
that. The recommended action comes from the,
Well,
Staff
if you go
report,
back and look
right?
at the staff report, it says 1 year.
oh, it does? Okay.
I don't have it with
We'll-
me, unfortunately.
You didn't bring last week's agenda with you?
So, yeah, right. I abandoned that one.
We'll
So I
double
can
check
make a
that.
motion to continue this while you check it out.
That's fine.
Okay, I move that we approve the July
17th.
17th and continue the July 24th minutes.
I'll second.
I'm just curious, what governs? I would always assume that the resolution would trump whatever the minutes say.
Yeah, it would.
But you would like
We
to
wanted to
have
reflect
correct minutes.
accurately, though. The resolution would control.
But I see, the reason I brought this up is I don't know what the resolution said. If it's different than what we saw. Okay, did we vote on that?
Not yet. Kathleen, can we have a roll call on that, please?
Commissioner Mazza,
Yes.
Commissioner Euring,
Yes?
Commissioner Jennings, Vice Chair Marks,
Yes.
Chair Pearson,
Yes.
motion carries.
Thank you. Now we're off to 3B2, extension of coastal development permit number 10-019 and site plan review number 10-014. A fourth request to extend the Planning Commission's approval of an application for the construction of a new single-family residence and associated development at 6156 Zumirez Drive. Who pulled
Did
this?
you-
Out of curiosity, okay.
Did you want a full staff report, or?
No, I have a question.
Okay.
This will be the 7th year when we approve this, is that correct? If we approve it.
Yes, because the original approval was in May of 2011.
Okay, and we typically don't approve things when the code changes. There's a whole, can you describe why this is now a 3-story house and how, because I'm looking at it as a 7-year extension with a code change, with a change in whatever, and now a 3-story house. So to grant the extension, I need to know that we do what we normally do.
The home was designed at that time in before 2011, with the basement and the first floor within the same elevation. I provided that in the staff report under the cross-section under page 3. You can see that the basement is just behind the actual first floor. There is no access from that basement to the first floor. However, it's provided from the floor above. So it's not necessarily a 3-story condition. It's just that the basement is not designed as currently practiced.
Okay, but we did change the code on basements after this approval, is that correct?
No.
No.
This project was approved using the current basement standards. It's just it's one of those changes in the way that we look at basements. When this was approved, let me say it this way: if someone proposed a basement and a first floor that were at the same elevation today, we would require a vertical separation in order for that to be an actual basement that doesn't just continue into the first floor. That's the difference. It's more of an application of the code. There's been no change in the text of the code. So the applicant was approved this way, and the reason for our recommendation for approval is that in looking at, what are the visual effects of this distinction in the way the code is applied then compared to today, if you had them eliminate the entire basement and just fill it up, the house would look exactly the same from the outside. The current owner bought the property I think a bit more than a year ago, and has been working on new plans. And since there's been a change in the way that extensions are considered, there's a new urgency to moving this forward from what we've heard from the applicant. So they've been making diligent progress towards getting into plan check and pulling permits. So given that, that was the basis of our recommendation for granting one more extension.
Okay, Carla?
Also, we do have a speaker on this, just to let you know.
Okay, just one last question, we'll have a speaker. Carlos, where does it stand? It indicates that you have complete plans, do you?
Yes, staff has been working with the applicant since March of this year. They've submitted plans for substantial conformance review, and I have gone through the project plans, and they have provided plans to me that are within substantial conformance of the previously approved project, meaning that the actual building proposed now is within the previously existing building envelope, and they're going from a 28-foot pitch roof to a 24-foot flat roof. And they're not going beyond the envelope or the building footprint that was previously approved in 2011.
And does the square footage change?
No, they're proposing plans again that are within the parameters of the previously approved project. The square footage is consistent and comparable to the previously approved. Those are some of the things that we check for substantial conformance.
Okay, so you expect this to be, I guess, I don't know, you're going to do a substantial conformance, or do you expect to permit within the next 6 months?
Yes, the actual architect, the applicant, has been working, and he has provided revised plans to me relatively quickly. And I currently have the latest revised plans where they, from what I understand right now, they are within substantial conformance of the previously approved project. And I believe that the applicant has done what they can to provide to me all the plans based on staff's comments to date.
Thank you.
Okay, we have two speakers. I'll open the public hearing. First, we have Roger Krath. I can't read the Roger K. How's that?
That sounds good with me. So, good evening, honorable commissioners. My name is Roger Karaf of Design 21. I'm working with the client that is here as well on this project. He purchased the property last year in the summer and closed escrow in the fall. And we were trying to acquire plans from the previous architect, couldn't. So we had to retrace everything, understand the project, and then we started immediately the new process for compliance with the design. We made the new design smaller, not so tall, and just architecturally more appealing than the original design. That's what we think. Also, the massing got a little bit reduced. And we keep it within the square footage, and we basically follow the original footprint of the original house, just make it a little bit smaller, and the height stays the same, the section stays the same, so everything pretty much stays the same. We already went to the point that we have completed all the architectural documents, so we have all the details, everything is done, even though we submitted the conceptual plans in March, or was it in beginning of March, and we're basically just working with staff to finalize so we can get the green stamp and can move forward with everybody else. We also hired a structural engineer already. We're working with him. We already started that process. We are working with Geo, everybody. We are basically just waiting for the green stamp so we can move forward and obtain the building permit. Financing is secured. Everything is there, so the client just wants to move forward and get basically the project approved, or at least get the green stamp so we can get all the other permits. And the moment we have the permit, we're gonna get start construction a week later. So it's really an interesting project. I think it will help the city of Malibu, just kind of like with the design that it is on the street. My client has another project on the street that is under construction. So we'll just kind of like really make this whole thing very beautiful, and we're interested to build, so it's not anything else than just get it built. And that's also the reason why my client bought the property, because he bought it with approved green stamp. It just needed to be adjusted to the new standards because it just doesn't look as appealing. And we kindly asked the commissioner to approve the extension so we can move forward with this process and get the building permit and get it constructed. Thanks so much for your time.
Thank you, Roger. Norm Haney?
Thank you again for the opportunity to speak to this. With regard to basements, I really didn't have a client. I had somebody that asked me for my professional opinion, and it had to do with an uphill project on Sea Level Drive. And the garage went into the side of the hill, and he built 2 stories above, not above the garage, but up the hill. The garage would have qualified for a basement under the old basement standards, but because the garage door opened and could be seen from the street, notwithstanding the fact the street was private, that garage became one of the parts of the first story, not a basement. At the back of the basement, way under the ground, he had a workout gym. And he couldn't enter into it from the garage, even though the back of the garage was right next to it. He could enter in from the top. And he was approved as a basement. That gentleman was Andy Stern. And I told him when he was considering the new basement ordinance, you understand that if you approve this, it's likely the city's going to say you've got a 3-story house. And he said, why? I said, because the garage is not a basement and you're immediately adjacent to it. He said, but there's dirt all around. There's dirt around the garage even. I said, it's not where the door opens. There's not. Anyway, he was approved. His house is built and he lives in it and he's a very happy man. But there are a lot of things to consider when you look at something like this. And I think that Andy Stern's workout gym or bedroom, whatever it happens to be, because it enters from the top and not from the garage, the back of the garage, it still should be considered a basement. Thank you.
Thank you, Norm. Is there anyone else who wishes to address the commission on this item? Okay, seeing no one, come back. Motion or discussion?
I'd like to make what I think will be the last motion to approve a project after 5 years extension. At least to be my last time. So I move staff's recommendation.
I'll second it, but I want to make a comment. It has been our unvarying practice over the years that when an extension comes up, the only issue for discussion, the only issue for resolution is there good cause to grant the extension? We came, in this case, a little perilously close, in my view, to examination of the merits of the original approval. If we go down that road, you think our meetings are long now? Every project, every controversial project we ever approved will bring all the same parties back to re-argue the case. So it was a salutary rule that we only consider that one issue, and I think we ought to stick with it. But I'm going to second the motion.
Thank you.
I do have one quick favor also. Bonnie, can you just clarify what is expected on August 28th so the public has more awareness of what process is happening with respect to extensions?
Sure. And I'll also mention that we're in the process also, I think we discussed this previously, that it would be good to try to provide some sort of notice to people with existing permits that the commission is, the rules are not changed as of today, but the commission is looking at the due cause question more closely. And so we're in the process of doing that this week. August 28th is when the City Council will consider the Planning Commission's recommendation on an amendment to the local coastal program that deals with how extensions of CDPs are treated, and that would involve a limit on how many times a permit could be extended. That's the major change, among some other things. So people that are interested in that topic, I would encourage you to keep an eye out for the August 28th City Council agenda.
That would also amend the municipal code?
No, it's just the local coastal program.
And if you're sending those out, why don't you send out a notice that the lighting ordinances might be changing too? And people should be aware of that if they're putting lighting in now. So
We will do that.
they don't have to fix that too. All in favor? Aye.
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 Anyone opposed? Nope. Measure passes. Moving forward on and to number 4A, coastal development permit number 15-056 and site plan review number 15-037, an application for a new single-family residence and associated development at 6701 Ports Head Road. And before we start, I just want to say I'm really sorry we did not get to this item before. We're not in control of our schedule, and we're not in control of how long people speak. So I apologize. I know that's frustrating. It's pretty rare, but you just got the rare one, and sorry. So if we could have a staff report, please.
Chair, members of the Planning Commission, the project before you tonight is a coastal development permit and site plan review at 6701 Ports Head Road with a request to construct a new single-family residence. The subject site is a vacant rectangular-shaped lot located at the Point Dume residential neighborhood. Surrounding properties are zoned RR1 and are developed with 1- and 2-story single-family residences. The site's topography descends from Ports Head Road towards a stream located at the rear of the property. The parcel will be developed within the portion of the site that is closest to Ports Head Road, which is the flattest part of the site and consistent with neighboring residences. Here's the vicinity map and aerial of the project site. The proposed project is a request to construct a 7,314 square foot, 2-story single-family residence with a 921 square foot attached 3-car garage, an attached 647 square foot pool house, and a roof deck and trellis, pool deck, swimming pool, spa, and associated equipment, outdoor fireplace and barbecue, retaining walls, landscaping, hardscaping, and grading, and other associated development. The project also includes the construction of a new alternative on-site water treatment system. The total development square footage allowed on the site is 9,032 square feet, and the proposed project will total 8,882 square feet. The project includes a site plan review to allow the portions of the main residence and detached pool house to be constructed in excess of 18 feet in height. Here's the site plan of the proposed project. As the plan demonstrates, there are 2 points of access from Ports Head Road. You have the proposed alternative on-site water treatment system within the northeastern portion of the site by the garage. You have pool decks within the central portion of the site, and you have a pool, and then you have a pool house on the southwest area of the project site. As designed, the project conforms to the residential development standards contained within the LIP. The project complies with the required setbacks, providing a 65-foot front yard setback, a 382-foot rear yard setback, and an 18-foot side yard setback along the south property line, and a 35-foot side yard setback along the north property line. Staff has determined that the project as proposed and conditioned is consistent with all applicable LCP codes and standards, goals and policies, inclusive of the site plan review for height. Here's the elevation of the proposed single-family residence. The east elevation here is what the portion of the building that will be facing Ports Head Road. You have the west elevation here that is facing towards the rear of the property, facing towards that drainage course. Here's the south elevation and also the north elevation for the proposed single-family residence. Along the south elevation, you have the detached pool house and the trellis. With regards to the 2/3 rule, here are the portions of the building that are over the 18 feet in height. The area above the garage would be a portion of the building where you have an excess of height there, over 18 feet, and along the western wing of the residence above the gym area. LIP section 3.6 limits heights of structures to 18 feet. However, the applicant is requesting a site plan review to allow portions of the house and detached pool house to reach up to 24 feet. Those portions of the main residence and detached pool house will be at a maximum of 24 feet, consistent with the site's topography as measured from the existing and natural grade. As these plans demonstrate here, a portion of the western wing of the main residence is above the 18 feet, and the pool house and deck and railing will be at a maximum height of 18 feet. However, a portion of it will be over 24 feet in height. This here demonstrates when staff did do the analysis and assessment of how this project ties into the community and neighborhood character. As this eastern elevation shows, what's facing along Ports Head Road, only a portion of the main residence above the garage will be over 18 feet in height. The remaining portions of the building facing Ports Head Road will be at a lower height at 18 feet approximately. So this is essentially what you'll be looking at as you're going along Ports Head Road. Again, only a portion of it is over the 18 feet in height. This is the north elevation. Here you can see that the site's topography descends from Ports Head Road towards the drainage course along the west property line. And the line in red is showing the 18-foot height limit from that western wing of the house. The arrow in green demonstrates the 23-foot height that's going to be proposed for this western wing of the house from the finished floor. However, as you can see, the existing site topography is above the actual finished floor, so essentially the building is actually not that tall when looking at it from the northern adjacent properties. Here are the story poles of the proposed project. They were installed in May of 2017. Staff did visit the site after the placement of the poles, and based on staff site visit, it was determined that the project is compatible with surrounding development. The proposed project is infill development within an established neighborhood, and development is proposed near the street side portion of the lot, similar to nearby residences. Based on conformance with development standards, conditions of approval that are applied to the project, and existing surrounding development, the proposed project is not expected to have an adverse effect on adjacent properties or the neighborhood character. Staff would like to note that there, on the staff report, there was an error on table 4. The property to the north, 6611 Ports Head Road, was mentioned twice. However, the correct address should be 6585 Ports Head Road, which is the second property to the north of the project site. With that being said, staff recommends the adoption of the resolution 17-39 approving coastal development permit 15-056 and site plan review 15-037 as conditioned, and that concludes staff's presentation. I'm available for any questions.
Thank you, Carlos. Thank you for the report. Disclosures. Jeff?
Yes, I visited the site this weekend, mainly to look at the neighborhood and the surrounding homes in the area. The data is pretty much in the staff report. The only thing I should mention is the home directly across the street, that actually the entrance is on Selfridge, the address is on Selfridge, is a large home, a large estate, that I'm very familiar with. It's been there for at least 35 years. One of my children was a good friend of the child who lived there, so we were in and out of that house all the time, so I'm just aware of how long it's been there. And apart from that, the rest of the neighborhood appears to be an area of large estate homes on large lots.
Steve?
Commissioner Pearson and I visited the site prior to the first time we were supposed to come in front of the Planning Commission. We've not been back since then and didn't learn anything that wasn't in the reports.
John?
I do know several people in the area, including Pam Ulick, but I did not visit the site.
I don't have any disclosures today on this one.
Okay. My disclosure would be similar to Mr. Uring's. We did visit the site and walked around it extensively, and it's all in the report, but got a much better sense for it by being there. closures. And questions of staff?
Like to hear the,
One more time?
I'd like to hear the speakers first.
Okay, well, let me see if anyone else has questions before we go. Jeff, unless we should just make that motion right now. Jeff, do you have any questions? No questions. Steve? No.
Just a quick one. You said that the street address is wrong. I assume the size is correct, though, right?
Can you repeat that question again?
Sure. You just said 6611 was repeated. I assume the square footage is correct?
Yes, that is correct. All the information provided is correct, the square footages and the size of the homes. It's just that the address was incorrectly stated in there.
Okay. And then on these, is this from the 500-foot radius map, or how was that list arrived at?
No, there's no basis for a 500-foot radius or 300-foot radius. I just simply looked at 2 adjacent properties or 3 within the vicinity of the project site. That's I had limited resources, so I just went ahead and tried to figure out what's consistent and what's within the area of the project site.
Okay, thank you.
Can I ask him one question?
No, you can't, because you said you wanted to open the hearing.
Okay, no, I just on
Okay,
that
one,
table.
just one.
What's table number 4?
Page 11.
I notice on this house is basically on an intersection of Selfridge and Portshead. But on your table, you only have one house on Selfridge. Is there a reason why you didn't do the other houses on Selfridge?
There is no reason why. I went and got the property to the northeast that had the Selfridge address, and the property to the southeast that was along Portshead. I didn't go further down Selfridge because it's primarily along Portshead Road. That's the only reason why I went ahead and only included that one property on Selfridge. Additionally to that, you do have the other properties to the north are adjacent to the project site, and being that this property was across the street, I felt that only one lot would be appropriate east of the project site.
This is, well, the city council, when all this stuff came up.
Is this a question?
It's a question, yes. They kind of, as we got a report last time, it was kind of a mix between neighborhood character and neighborhood standards. Is there a reason why staff doesn't use the methodology they used of the nearest 10 houses and all that stuff, 500 feet?
We're going to, as I mentioned, to council to get better direction. The discussion on the Via Acero appeal at the city council several weeks ago was very interesting. It was a site-specific, project-specific discussion, and so we listened to the city council, but did not take that as precedent for each and every other project that comes before us. So essentially, that's the short answer.
Thank you.
Okay, with that, I'm going to open the public hearing. We have a number of speakers. The applicant team is Chris, Doug, and Joseph. You have 15 minutes. Let me know if you want to reserve any time for rebuttal to anyone of the other speakers, and there you go.
All right. I'm Chris Murphy, the owner of the property. I just wanted to come up here and thank you for your time. I know you're all volunteers. We moved from Illinois a year ago, and my wife was a city trustee back there, and I know how much time she put in and a lot of grief she got, and I know that your job's not easy, so that I do want to acknowledge that. I also want to acknowledge all the hard work that Carlos has done and thank him. Thank you, Carlos. On behalf of my son, Finn, my daughter, Parker, and my wife, Paula, we can't tell you how excited we are to become part of this community. It's taking a little bit longer than we thought, but it's going to be worth it in the long run. We're currently renting a place right around the corner, so we have kind of already started to integrate ourselves here, and we absolutely love the people, the place, and hopefully the only missing piece of the puzzle now is to have a home we can call our own. So thank you for your time.
Okay, thank you. Applicant team, Doug?
We got a few extra graphics that were not part of Carlos. Let's stop there. Okay. Good evening, Commissioners. Doug Burge, the architect for the project. Just a little bit of history is that we first were asked to design this property for a previous owner who had owned it, and we started our plans back in May of 2015. And then in August 2015, we submitted a CD application at that time. And then around March of 2016, about 6 months later, the Murphys had bought the property. And at that time, the project was fully into the city. We had actually received pretty much all of our sign-offs and approvals from the other departments. And the current design, original design was actually a sloping roof house of 28 feet. And the Murphys had come in and talked to us, and they desired a more modern home being 24 feet. So we then changed the plans. We talked about substantial conformance with the city. As a previous applicant who was just here just tonight talked about it, we had, again, another owner, a different maybe design, and so we changed the plans. We kept the footprint pretty much as it was. We weren't going to add any square footage. We knew that we were asking for a smaller massing house, and we didn't want to start the process over. So we continued with the process, and then in almost December of last year, all the basic approvals were in without planning, and then planning had to go through some more issues to get the final deemed complete project in May of 2017 of this year. And obviously we all know our hearing was supposed to be in July, now we're in August. So it's still about, considering there's two owners, about a 2-year process. And what has to be understood, and I think we all know this because we've been through this for so many projects, is that we have 7 different agencies, and all the agencies have their own rules, and we go through and we try to abide by the code. We tell clients early on, let's try to keep things with no variances. Let's keep within the heights. You'll never get a height increase. You'll never get a square footage increase. You have to be careful with your basements. Us that have been practicing here in Malibu for a number of years and hopefully get hired because of our knowledge of the codes and our understanding of how to get a project passed. Just recently, obviously, we have these new issues with this neighborhood character issue, which Joseph will be addressing in more detail, showing how if I were going to be the one determining how to make neighborhood character a rule, then this is how we would be looking at certain points. And we'll be bringing this up again on the hearing or the discussion that's come up later on this month. The other thing that's critical here is that we do, and it's not part of the code, but it's part of what I think everyone needs to do, is you got to meet with your neighbors beforehand, because you eventually will get the geology and the septic department and all these departments to pass the house, but it's the neighbors are going to be the one that are going to be maybe concerned the most. So we met early on with both the most affected neighbors, which I felt the side neighbors, because we have a vacant lot. There's nothing there. They have a view across it. Maybe their dog uses it. Maybe they just like going over there and just using it for open space. But the point is that the property on the right of this house was owned by somebody that was in our church, and we knew them, and we met with them early on, and they had concerns because their only view, and they have a flat house, 1-story house, pretty large in square footage, but their one view was actually towards our project. And we said, what can we do about that? So I said, well, we have a vacant lot. Let's move our house over as far as we can, actually towards, in this case, the south. So which is what we did. We created the fire turnaround, and that's a side road along that side. So we're not stuffed against their side yard. We did our site planning and solar studies. We met with them early on, and they were very pleased with the design. The other side of the neighbor was a notable realtor here in town, and we met with them. And they were satisfied with the design. The only massing that's on their side of the house is a 20-foot wide living room. And so it wasn't like you're looking at a big wall. So we take into effect what neighbors have concerns with beyond the code. And then we have our code itself. The TDS determines the square footage. The 2/3 rule is supposed to take care of massing. As we all know, there's a lot of unattractive, possibly unattractive, and the eye of the beholder homes that are around. And in Malibu, we supposedly can't say anything about them. So neighborhood character, typically in any other city, if you're in Santa Barbara, that would be 100% determined on what it looks like. In our case, it comes down to massing, square footage of a lot. This just happens to be, and Joseph will describe this in just a little bit. I didn't even believe this, but this is actually one of the largest lots in all of Point Dume. And then we have to determine what makes a neighborhood. Is it 3 houses down the street, 1 house across the street? If you ask people in Point Dume, they consider it's all of Point Dume. Because if you have a house in Point Dume, especially in this case, you have a beach key to a lot that's at the very end of a street. So you have to go past all the houses even to get to your beach. So that's like property rights extend beyond this house all the way down to the beach. So everyone in Point Dume considers Point Dume a neighborhood. We have this discussion over on Cliffside. Is it just Cliffside? No. You walk your dog, you stroll, you enjoy that community of Point Doom. And we'll talk about that later on in the month of what defines a neighborhood. So we looked at this very seriously. And I go to this slide because in this particular case, we have a sloping lot. In this particular case, we drive in, we can't change the height of the street, but we can change the way we come down onto a property, that we can make the massing not as large, even though Carlos brought up the elevation of the house. That's an architectural elevation. It doesn't show that this particular front door is over 10 feet below the level of the street. So once you actually get that, if you take a string line, and the only section of the house that you actually see, it even looks like a one-story house, is the second story that's over the garage, and that's the only second-story section that faces the street. And the other thing that I've asked Joseph to study when we look at this massing and we look at these neighborhood characters is that what's a two-story home or what's a one-story home? That's easy for us to define. And what's a 1.5-story home? In this case, we say our house is 1.5 because it's not all 2 stories or not all 1 stories facing the street. So neighborhood character, it's a new topic. We're going to deal with it. We, as architects, and there's a lot of us that we feel like we've been around and we can talk to the subject pretty strongly, is that, and we will talk about it later, but in this particular case, a lot of thought has gone into the design of this house. Square footage is a massing issue. If you got a bigger lot, great, you have more square footage. It takes over 2 years to get here. We tell clients to do a master plan for your project. Don't do piecemeal. The city doesn't want piecemeal. Oh, let's go to a 2,500 square foot house now. Let's apply for another 2,500 square foot later. No, it takes so long to get here, and we all know that. And we say go to the Planning Commission once if you can. Get your project approved. It may be a master plan, it may be a detached guest house. They may not get that guest house built now, they may build it later. This particular client took our plans that were already approved, almost approved, made the changes to make it more modern, actually reduced the square footage than what it was, worked with some builders on the budgets, and here we are today. So I only ask you to look at this as something that we have these new conditions. I can only give the analogy, if the state of California decides to change the speed limit from 55 to 35, the next day they don't immediately change it. They put a date that affects a change. And we're all looking at this pretty aggressively, and I only bring that up because I think we have to be careful about analyzing projects that have been going under the gun already for a lot of rules for over 2 years in some case, and we're looking at a whole new set of rules that affect a design that we should have known about in the beginning. So with that, I'm going to let Joseph just go through a little facts here with the time remaining, and then I can close. Thank you.
Okay, thanks.
Good evening, Chair Pearson and members of the Planning Commission. Joseph Lazama, Bergen Associate Architects. As previously mentioned, our project has been found in compliance with the majority of the development standards required of this RR1 zone property. And since our clients felt that their needs could be met with the development allowed by the LCP, we did not elect to pursue anything like increased height, structure size, or development area beyond the letter of the LCP with anything like a neighborhood standards discretionary request. Here's that photorealistic rendering of the east elevation. From the street view, the edge of Ports Head Road is outlined here in red. This is a plan view of our planting plan for the front portion of our landscaping, again showing that all of our proposed improvements are positioned outside of the public right-of-way. Here's another rendering. This time it's of the west elevation. You can see the green roof off to the right and the small area where we're proposing to build in a 2-story fashion to the left. Again, our project has been found to be in compliance with the majority of the development standards, but in order to cluster development and preserve the existing building pads, we are applying to build above 18 feet, but not above 24 feet with the discretion of a site plan review. With neighborhood character being the most discussed finding in recent months, we have prepared statements that we feel support the making of finding number 2, the finding which states that the project does not adversely affect neighborhood character. As discussed, since it's our understanding that the City Council is not giving the Planning Commission direction or a definition of neighborhood character, we look towards the general plan. The general plan states that the essential character of Point Doom is a predominance of single-family homes on lots that are extremely large for parcels on the ocean side of Pacific Coast Highway. Point Doom has a lack of sidewalks and streetlights, as well as roads which are rarely straight or flat, all of which adds to its rural atmosphere.
Many homes have ocean views or ocean sounds, while others have mountain views. The surrounding beaches are both traditional Southern California wide sandy beaches, such as Westward Beach Road, and others are unique, like Big Dune Beach with its tide pools. Original construction on Point Dume customarily consisted of single-story ranch-style homes in the 2,000 square foot range with building standard type interior finishes. However, homes constructed on Point Dume since approximately 1985 have been large, often finished in an opulent style. Such homes now constitute a significant, although not overwhelming, portion of Point Dume. Such larger homes are particularly prevalent on the perimeter drives, such as streets as Cliffside and Birdview, while the previous styles are elsewhere on Wandermere. The general plan section goes on to describe multi-unit commercial, recreational, traffic, crime, and other hazards on Point Dume, but we feel it's most important to note that even at the time of the city's incorporation, there was a strong understanding of the amount of square footage and type of construction to come. If the language of the general plan tells a story of Point Dume, then the MMC and LCP predict its growth. This slide shows the area we studied for our comprehensive look at size, bulk, and height around the project site. We feel that these 70 properties make up the neighborhood that our project is located in. The average amount of square footage per lot in our neighborhood is 3,247 square feet, and the average square footage to land ratio is 4.7%. Our project is the largest property in this neighborhood, and with its 7,314 square feet, our home to land ratio is only 6.6% and in the 48th percentile of this neighborhood. It's most important to note that the average number of stories in our neighborhood is 1.45. Again, our project fully respects that statistic by the positioning of 11% of our proposed square footage on a second story visible from Port's Head Road. We feel that not only does this size protect neighborhood character, but it has a mindfulness in its massing and position. Lastly, commissioners, during the site visit, a question of shadows came up. This first exhibit shows the shadows during December 21st. And this exhibit shows the shadows on June 21st. These are the days of the year where the sun is lowest and highest in the sky and therefore capable of the most dramatic shadow comparison. Also, Chair Pearson, you had a question about the wood chips on the property when we were walking the site, and our client can attest that those were a chipped up eucalyptus tree that had fallen during last winter's storms. The client, Doug, and myself are here for any other questions that you may have.
Okay, thank you. So you have a minute and a half left. You want to hold on to that for now? That's a big yes. Okay, a few more speakers. Next up, we have Beatrix Alinkas.
Good evening, Commissioners. I'm here just to make a comment on this project. It's too big, and I say that based on the size, bulk, and height compared to the rest of the neighborhood. Beautiful family, beautiful design, but the house is going to be the biggest one in the neighborhood by 30%. And effectively, it will adversely affect the neighborhood because now the smaller houses in the area will be reduced to their tear-down value only. I think there's a reason why the language was put in the LIP for neighborhood standards and neighborhood character, and I look forward to this discussion because what's happening is developers and the planning department interpreting the rules the way they do are changing Malibu, and that charm that attracts people is being destroyed. You could kind of see it in that video that the architect just showed, you know, the difference between the ranchy fences and kind of like the open landscape versus the 8-foot-high hedges and the walls. So it's kind of like a battle for the soul of Malibu, and I don't begrudge them building a house. I think their house is beautiful. It just needs to be reduced so that it fits in with the neighborhood that they're going into. So that's my comment. Thank you.
Thank you. Pamela? followed by Norm.
Hello again, and just wanted to say something. I really didn't know this Murphy family. I got to know what was happening from reading Next Door, which I'm sure some of you are on, and I read a statement by Mr. Murphy, and it really made me feel sad to hear that they might have left Malibu because of this issue of whether they can build or not. And so after I read that, I wanted to show that some people, I live down the street. You heard my story, and I just wanted to clarify too. It was 4 years, but we actually made the changes at the Planning Commission outside that too. But it took a long time. And when I read his statement, it just triggered something in me about being able to help each other. And I appreciate what my other neighbor said, and I feel for her as well. But at this point, I really feel like the law should be upheld. After I read his statement, we started a petition online supporting letting them build their dream house. It may not be what I want, but I didn't buy the property, they did. It's over 2 acres, and if you look at the neighborhood character, I think it fits great into it. I live down the street. I think it's gonna be a beautiful home. It's tasteful. After we put the petition online, it received 33 signatures of other people supporting them building their dream home. I think 27, is that right, Carla? Give or so of these 33, I submitted them to Bonnie Blue. You'll see 27 of these people lived in Malibu. And I really think it is important that we support our neighbors, and maybe we might not like the exact square footage, but they have over 2.5 acres. And if I didn't want anything to be built there, then we have something in this country, it's called you can buy that lot and prevent anything from being built. And I feel like once you buy a lot, you have the right to do with it what you want. And I'm grateful I live in a country that's free, and I hope that we will honor the laws that we have drafted. And I understand if you don't want anything built anymore, then the new city council, the new people can draft a law saying that, and it will be vetted constitutionally, and they can change it. But right now, they're building within the law. I've showed you the petition of 27 in Malibu plus people supporting them in their endeavor. And we look forward to welcoming them and their beautiful children and having them be part of the soul of Malibu too. And I appreciate all of our neighbors, and even if we can disagree on this, I really want to applaud you for coming out here tonight, the neighbor who just spoke, because it takes a village. Thank you for your time.
Thank you. Norm Haney.
Thank you for the opportunity to speak on this project. You all have heard my previous comments with regard to what the city has followed for 24 years. And people, I believe, have a right to rely on that when they design a house. I do believe that this house is not only consistent with the standards that were adopted by this city and have been followed for this many years and accepted by the California Coastal Commission as well, but I also believe that the house is consistent with the character of the neighborhood. When you consider character of the neighborhood, you're talking about how does it look? How does it look with respect to other houses in the area? Because as you drive down the street, all you can see is what this house looks like from the street and how the other neighbors' houses look like. This house looks absolutely consistent with the other houses on the street. In terms of size, nobody knows how really big it is. I mean, it goes down the hill and it stacks down the hill and it meets the height standard. It's impossible for someone to know whether this house is 6,000 square feet or 9,000 square feet. So you go by the way it looks. And I absolutely think the architect did an incredible job in massing and trying to be considerate of what people see from the street side. Much of his testimony was based on what you see, and I believe that it is consistent with the character of the neighborhood. So thank you for your time.
Thank you, Norm. You guys have a minute and a half or a minute something if you want any more comments. Okay, does anyone else want to address the commission on this item? Okay, seeing no one, we'll close the public hearing. We're back here. Discussion or motion or questions of staff?
Carlos, Doug Burge said that they had reduced this house in size from the prior plans. But when I look on the table, it's 50 square feet below the absolute maximum. So what was that reduction 50 square feet? Was the prior plan right up to the limit?
I don't have the previous plans in front of me right now. The previous iteration of the project, when it was 28 feet in height with the pitch roof, I believe the square footages were somewhat comparable and similar, but I don't have the exact numbers.
Okay.
The staff report talks about the previous CDP being for 6,788 square feet for the residence with an attached garage.
So it wasn't.
And a basement.
So it wasn't 9,000 feet.
But I mean, it had additional accessory structures.
Okay, well, we're talking 50 square feet, put a golf cart in it. Now, when we discuss size of lots on Point Doom, anything with a 4-to-1 slope or greater is unbuildable. How much of the pad is left on this property if this house is built that is buildable?
On my PowerPoint presentation, I have a supplemental slide that shows the slope analysis. However, I believe that the area just west of that detached pool house is the areas that exceed 4-to-1 slopes. So it's essentially the portion, the center portion of the lot towards Port's Head is the only area that's that can be developed.
So the 2.4 acres comes up through the formula as a number, but in reality, the building area is fixed by the 4-to-1 slope. Is that a correct statement?
Yeah, that's right. I mean, you can't, the standards in LIP Chapter 4 do not allow development on slopes of 25% or steeper.
Okay, my next question would be on size. Joseph mentioned that I think it was 70 houses they looked at were about 3,200 square feet. And if you take your table 4 and eliminate this project, as I remember calculating it out, it's about 3,300 square feet. So that's about the neighborhood. Do you disagree with those numbers? I mean, as far as the general size in the neighborhood, or what different people call different neighborhoods?
When staff did the analysis for neighborhood character, we didn't necessarily look at the average square footages or TDSF. We looked at the massing and the scale of the proposed project and the areas that are above 18 feet because that is where the site plan review applies. So when we looked at this project, yes, the house is set back 65 feet, which reduces visibility from Port's Head. Only a portion of the home facing Port's Head is over 18 feet. So again, I can't say whether or not the 70 homes that the applicant is presenting tonight demonstrates a better picture for neighborhood character. Staff didn't go by those numbers and we don't have those averages. I simply went by the homes that are existing within the vicinity of the site, the sizes of the homes. Yes, this home is somewhat larger, however, they are on a larger lot. So we didn't have a detailed analysis as to lot size, square footages of homes, TDSF on adjacent properties, because a lot of those homes were built in under LA County, and we just don't have the resources to give you an accurate number as to what is permitted out there and what sizes are out there.
Yeah, but my real question is the elephant in the room. I've lived on Point Doom for 44 years, so I kind of know what houses look like there. What I'm getting at is somewhere between 3,000 and 3,500, would you agree from the numbers they gave in their testimony and what you have on this table is a semi-accurate description of the average home in that area?
I think what Carlos is saying is we just haven't looked at it that way.
Okay, well, so the real problem here is, as far as I'm concerned, the thing we are looking at tonight is neighborhood character, and you're saying you have not analyzed it.
I think that part of the complexity of this issue is that neighborhood character isn't defined and it's a subjective question. And I think the applicant raised a good point that, you know, some people consider the entirety of Point Doom to be their neighborhood, not just a particular block or street. The neighborhood standards portion of the code, which, you know, hasn't been applied for here, but that, you know, prescribes a different way to look at what is a neighborhood. So, since the request here was related to height, that's what we focused on in terms of a visual impact.
Okay, but my question, what I'm trying to get at is a way to look at this, because we had a presentation at the last meeting on how we deal with this. We saw what the city council did. We have to have somewhat of a baseline. We look at your table, and the very biggest house is 5,500. I know from driving the area that there's a lot of little houses on Selfridge, you know, 1950s houses. But what I'm trying to get at is, are we looking at, no matter how you define the area, 10 houses or 72, the average is somewhere between 3,000 and 3,500. Is that a reasonable number? Because the number you came up was 3,200, I think. You didn't average it out, but you can add them up and divide by 11. It's pretty easy.
I think, I mean, and we just simply haven't done that math to determine what is the average based on that neighborhood. I mean, if you want to ask the applicant more questions about where they got their data and that sort of thing, that might
Okay,
give you
well,
a comfort
in my
level.
mind, then I'm just going to take what's the biggest number that's been presented to me, and that's somewhere around 3,200, because the applicant said it and your staff report says it. We have to go on something. So that's what I'm going to have to go on. Now, I know we're going to have to wrestle with this, but this house at 9,000 or almost 9,000, am I incorrect saying that's about 250% at 3,500? So it's 2.5 times as big as everybody else? Not everybody else, the average.
It says here 7,300.
Yeah, but forget that. It's really 8832 or 8882. Go to table, go to
Page
table
6.
3.
I guess my question would be back to you, and I don't know the answer. The numbers you're looking at other houses, does it include the auxiliary structures too?
That's a question, and so, and
They
I know
tend
I'm
not
not,
to, I don't
I
think so.
know that people say that, and then I know I've looked at other houses on web services, and those numbers are readily available, and they seem to match up, including guest houses and ancillary structures. Not Zillow, but some of the other ones. And I did not do it on this project. That's why I'm trying to get down to what our baseline is, and we can discuss neighborhood standards. But I'd like to start at a point where we have some agreement on sort of what it is, as far as
I
size
don't
goes.
think we know. I mean, we don't have the hard data is my only
Well, we
worry.
have it right here on table 4, and we have what Joseph said.
Let me offer a different analysis, if I could. Neighborhood character comes into the equation only because there's a site plan review. Or the other time it comes in is when you're talking about a minor modification, which is just weird, but okay. In this case, we're talking about a site plan review. That's why neighborhood character is important. Now, what is a site plan review for? It's for the portion of the building that's above 18 feet. You knock off the portion of the building that's above 18 feet, they can build this house as a one-story house, and neighborhood character never comes into the equation. It never comes into the equation, John. Let me finish before you jump on it, all right? You can spread this house out. Now, I know that you think that you can rely on the general plan, and maybe the city attorney will disabuse you of that idea, but it only comes into effect when you're talking about a site plan review. So it seems to me logical that in considering whether this building has a deleterious effect on neighborhood character, you look at the portion of the house that's above 18 feet. In this particular case, the portion of the house that's above 18 feet is dropped below the surface of the adjacent street to a point where it looks really like a one-story house. I just cannot see how you can look at the massing of this and say that it has a negative impact on neighborhood character when the same house, if reduced to a one-story house, could be built without considering neighborhood character.
Well, my answer to that is that our only example of this is what the city council did. And they took a house that was, and these are rough numbers, that started out at 8,800 square feet, and they whacked off everything above 18 feet, no site plan review, and brought it down to 4,500 feet for neighborhood standards. That's exactly what they did, and we don't have any other precedent. So you have your opinion on how this is done, but our only precedent is what the city council did, and without any other direction, we have to look at that. Now, there's other things about neighborhood character other than whether you can see it. And that's why, and you know, the dirty general plan talks about mansionization. But I live on a street that is gradually, I live on Sumarez, it's gradually, at one end of the street, everything's getting giant, okay? And I've lived there when everything was small. And it does make a difference to neighborhood character when you have 9,000 square foot houses, because you have more staff, more gardeners, more pool men, more this, more that. So it's not just a site plan review according to what the city council says. And so we have to look at this the way they look at it until they tell us not to. Now, if we make a mistake here, they can appeal, and then the city council can really tell us what they say. But I'm going to have and I haven't listened to what everybody says yet, but I'm going to have a hard time saying a site plan, a neighborhood standard is a house almost 3 times the size of the average house, and 60% bigger than the biggest house.
What are you going to say when they redesign the house as a one-story house?
Exactly what the city council said on Via Cerro.
Which
it's a
is,
one-story house.
Which is you don't care whether it's site plan review or not, you're just going to whack it down
No,
based on...
I'm not going to say this. I'm going to say that's my only precedent. The city council did not look at site plan review. They looked at neighborhood character.
But the reason neighborhood character was in question was the original design did involve a site plan review, and the revised design involved a site plan review for construction on slopes. And the other distinction from that case to this case is that it was visible from scenic areas. So I think it's important to remember that we have the entire, if you want to call it precedent, of the history of prior to the Via Acero project, and we have one project where the council looked at it in a particular way under a particular appeal. So that's why we as staff, in the absence of getting more clarification on this issue, haven't completely changed the direction based on this one project-specific instance.
But my question is staff didn't look at it as neighborhood standards. So how can staff comment on that? They did not do the
neighborhood standards,
design.
as we discussed last meeting, is a specific discretionary request. It hasn't been, no one's requested neighborhood standards here. There's no reason to apply it here based on existing law, existing codes. There's no existing I agree the question of neighborhood character is a subjective one, and I think you raised some good points about the other issues that come along with larger square footage. However, there's nothing right now in the code that indicates that neighborhood character is based on anything relative to the average size or square footage. We looked at it from the standpoint of, as Commissioner Jennings mentioned, what was being requested was an increase in height, and then how does that reflect on the neighborhood character or affect it?
Let me see if I can, see if anyone else wants to weigh in. Chris?
Yeah, I've got a few thoughts that are coming up. Let me just try to get myself a little organized. Does anyone else want to jump ahead? Or should I just dive in?
Steve?
The city council did use the neighborhood standard formula to determine the size of that house. Now, I asked the staff, because I just wanted to see what the size would look like if you use that computation. So I asked Carlos to just give me the houses that would have been included in that computation, and I had somebody else who was going to go out and do the sizings for us so we could do that, and they told me I couldn't get that. So I wish I had a better answer for that number. I think John's correct. If you look at the average size of the houses based upon the numbers that are presented to us, it's about 3,300 square feet is the average. Just seems like a very, very large house.
Chris?
Yeah. So I mean, there's a lot of variables here, obviously, that we're all struggling with. I mean, I'm trying to go back to my interpretation of what's in the vision and mission statement, kind of for a place to start. What jumps out to me: rural characteristics, present, future generations, general welfare, avoid suburbanization and commercialization. Just kind of jumping topics. What's written here: privacy of property owners, aesthetic values of the area, capacity of the area to sustain particular levels of use. So those all kind of seem relevant. I don't quite know exactly where apply to what. But when I play now through in my head what's been discussed today, I recognize that we don't have clarity on what we mean by neighborhood standards, neighborhood, I forgot the other phrase that's used, character, thank you. But when we look at the applications applied to 2885 Cliffside in item 5D last session, we had very clear numbers from both Joseph and staff looking at how far we set back a property. Is 35 feet far enough or not? Now we're looking at a 9,000 square foot house plus against a backdrop of a neighborhood which has been established as 3,000 and 3,500 square feet. It seems like even without full clarity from council, we could at least give this similar level of analysis and say, these are the 18 homes which were identified, these are the ones we threw out, here's why, these are the ones we kept, here's why. So at least we'd have something quantifiable. When I then start to look at what was the discussion against Via Cerro, there were a lot of factors in that, both the slopes, the visual from the public road on Canaan, et cetera. It was more than just kind of a quote unquote cut and dry story. But I still look at that and see, a lot of similarities here. And the biggest ones that come up to me are that it's the size of the structure is what I interpreted council's discussion to be the core of what they arrived at. I didn't hear any talk of an upper story or not. It's that it starts to shift the character of that neighborhood, kind of to John's point, to where it's becoming more suburbanized. You need to have certain staff supporting that house. You need other things which start to impact the aesthetic value of the area. I mean, I'm just kind of tying it back to my interpretation of what I've heard from council, what we've discussed here on staff, I should say, on the commission, and what the vision and mission statements say. And I'm going to just characterize all this by saying also, I agree, the house you have is totally cool. Really like the design. I mean, I think you're meeting a lot of the needs by setting it back, by not having a big monstrosity kind of staring at people in the street. It does, kind of meet what appears to be the nature of the character on a drive-by, but that's not what I interpreted from what council directed, which was more focused on size.
Okay, thanks. I'm going to give my opinion, then I'm going to ask for a motion because I think we've all been able to share our opinions on this difficult subject. For me, I feel pretty tortured, I'll be honest. Steve and I talked quite a bit about this. Even afterwards, we got together and went over because it's confusing, and we want to do a good job all the way around. it is a large home, and with what city council did, it's very confusing without further direction on what that means and where we go with it. At the same time, it fits within the code like it has for all my 6 years here easily, and that hasn't been changed. Except there's this Via Acero decision, which I've looked at over and over again, and I still find confusing because we generally deal with things a little more cut and dry here. I have a feeling this is going to get appealed no matter which way this house goes, because you're caught right in just the middle of just what you're caught in the middle of. And I don't know why, I don't know how that happened, but here you are. It must be really fun. So with all that said, I don't, and also I talked to your city council member, and this may sway my vote right here. I asked Rick about this because I told him this, you've put us in a really tough spot. And it just seems like every project, Rick, that's come along since then has been the biggest in the neighborhood. I don't know why that is. It's just, maybe it's meant to be, so this issue will be finally decided on. And what he said is, listen, while we figure this out, maybe some of the larger projects are going to go through. And that comes from Rick. So with that, with not sure if my decision is right or wrong, I'm going to support the staff's recommendation. I'm going to make that motion, and we'll go for a vote and see where we get. And whichever side doesn't like it's welcome to. I think we're going to move forward. I think we've had a lot of input here. I think we're pretty good. Is there a second on the motion?
I'm going to second it.
Okay. Can we have a roll call, please, on that?
Chair Pearson?
Yes.
Well, can you, before you do that, Sheriff, just, and I don't know which one I'm going to vote yet either, all right?
Okay, but fair enough. I'm just trying to move us forward.
Let's assume the motion fails for whatever reason, all right? And a decision is made to make the house smaller. What does it do to, I don't want to cut off their opportunity to do whatever, if they want to come back with another house, or they want to go to, how do we sure the motion we make doesn't do anything to
That's a great question.
Stop them?
My assumption was, if it gets appealed, like the city council did last time, they'd allow them to fix that there. I don't know if that's a poor assumption.
It's a thing that can get solved at city council level, you're saying?
Well, maybe that's a poor decision. I don't know.
The other option is to understand if the applicant would be interested in a continuance in order to make changes, or if they would prefer to move forward with whatever it is that you decide on.
Okay, that's fair enough. Do you have any comment on that, please? I should have listened to you earlier.
Can I hear that question again? What did you, I was talking to my client.
Bonnie, would you want to state that?
There was just some discussion about whether, how to proceed if there were a decision this evening to reduce the size of the house, and then presume that it would get appealed to the city council, and then the city council would sort it out. And I was suggesting that the applicant might like to have the opportunity to make changes to the house, or they may want to go forward with whatever is decided this evening.
Okay, well, I have another way. So we're hearing this issue of neighborhood character on the 28th, which is a few weeks away. Okay, we're all like grabbing at straws here. We're trying to say this is one square footage, that's another. And by the way, square footage to the assessors is livable square footage only. You have to compare apples to apples. We're really dancing around hot topics here, and we have no factual knowledge that we're going to be bringing to light very clearly on the 28th of the month. So our suggestion is to stay this project until we can extend this vote till after that decision is made, because we're asking for clarity, and only the city council seems to be the body of government that's going to give it to this board. And I'm only asking that because otherwise we're redrawing, and if we don't have to redraw, we feel we're right, we feel we're in compliance, we feel we've met the code, and I'd rather wait a couple weeks, if my client allows us to ask for an extension to the first hearing in September, because at that time, we'll know. The city council clearly draws a line in the sand, then that's the line in the sand we have to work towards. But right now, we have no line in the sand.
Can I just say one thing?
Please,
just 30 seconds.
Okay.
I just want to say that we're not a developer, we're a family. And every month that this gets delayed because we don't have answers is one more month that she doesn't get to live at her house This is our family, all right?
Well,
And when you guys
can I
delay
make a
us,
comment to you?
she's going to be moving pretty soon. She's going to college. I wanted this to be the home that she got that when she was a grown woman and she's talking to her kids about the house she grew up in. It was about this house. And we played by the rules. We played by the rules. When I bought this place, I thought we were playing by the rules. And now we're like, well, what if? What if? What if? Well, what if? Maybe there will be changes. But as of right now, we played by the rules. And every month that goes by is one more month that she is closer to leaving for college. And I'm just...
Well, let me
totally
just,
understand.
maybe we should do a 5-minute recess and have you talk to your architect, because Malibu's a strange place. And you can get in a cycle of appeals and stuff where it costs you a lot of time. Doug is basically saying, wait 2-3 weeks. In some instances, and you should talk to Doug about this, it can cost you a year. Okay, I would, if you would withdraw your motion, I'd like to make a motion that we adjourn for 10 minutes and come back and ask the same question again.
Well, I think that Doug spoke very well. I think I should have thought of what you said, and I would like to withdraw my motion if Jeff will accept that.
Well,
hang on a second, please.
Yeah, I mean, if Doug wants to put the matter over, my problem is that there's going to be a discussion in 2 weeks, and it's not going to resolve anything. There's not going to be a bright line because we got a code. They want to change the code. They can change the code, but that doesn't happen overnight. That's a long, drawn-out process. So if you're looking for clarity, you ain't going to get it.
Well, there's interpretation of the code, too. I think that's what we were hoping for.
No, an interpretation of the code is what Bonnie, from that point on, is going to do with it. And then it's down to us and our duty to interpret the code. And if we're right or if we're wrong and things get appealed and they go up to the city council, that's fine. But an interpretation of the code that is something that staff can do. The city council really cannot sit down and say, we're going to interpret this law that says, you know, in this particular way, we're going to apply this meaning to this without actually changing the code.
But they did.
But they did, yeah.
You have seized upon a decision which was kind of confused to think that it's a precedent. There is no such thing as precedent in planning. There is no such thing as each of these items comes up, it's sui generis. It stand on their own facts or they fall on their own facts. It has nothing to do with precedent. You grab onto precedents when a decision comes down that you like and insist that oh, that's what everybody has to do, but that's not the way it is.
Could I ask Doug a question? Doug, do you think it would do you and your client good to talk for 10 minutes and come back? Or?
I don't think it's talking to our client. It's obviously we're just trying to figure out what's going to take the longest. We say it's going to be appealed by who? Usually it's appealed from a neighbor's going to appeal, or we're going to appeal the decision.
Exactly. So,
to that decision, but we're also asking for an extension because then it's a no vote. An extension puts us to after that, at least the discussion will give some more clarity.
Exactly, but I seem to perceive your client wants to proceed right now and have us make a.
He's just frustrated. Why I would
I know,
be everyone's frustrated.
And shouldn't you two agree?
It doesn't really make any difference. If Mike's motion fails, it goes down 3-2 or whatever it is, it goes down. Then there has to be a motion to deny. And that motion to deny is then appealable to the city council. So it can move along that track just as rapidly as waiting until the 28th.
I mean, at this point, I'd be fine to make a motion following your lead, to be honest. I mean, you've worked so hard on this project.
We'll take the 10 minutes.
Okay, we'll adjourn in 10 minutes. Thank you.
You should remind people that we're not allowed to talk to you during this recess because it's a matter still under.
And the commissioners won't discuss this item during the recess.
No discussion.
Because they don't, they have the fault. And if they change, if they change the code, if they change the code, it's gotta go to the California Commission. They gotta change the local code for everything to do. No, it's not. And that's exactly what Jeff said.
And on the 28th, I'm bringing up your job. This is the disjustice that's happening daily. This is what's happening. These are real people that are trying to live and get the project back on current rules. It's like you just like say, you change the speed limit, you don't immediately make it. And that pulls you over, says, I'm sorry, I need to be a ticket. Yeah. You have to do it by governmental rules and do it by the time. So I'm saying we've gone this far, and we can take that discussion because then we're going to do it. It's September, first one September. Then we're going to have those examples and we're going to cite everything that was said. They're only listening to the council. They're not even making their own decisions. You've been hearing through the lines. Yes.
No, I'm just listening. It's a shame that they've done this, that they've taken the code and they're trying to change the code. Huh?
Norm? No. You need to listen to what he says. You think we should get the extension of master report because these guys are so influenced by the council. I want them to, even though, yes, I'm not accepting it. There's not a final answer going to happen on the 28th, but at least they're all going to hear what the general consensus is. And we're going to bring up this example of the injustice that's happening throughout the community, and I'm going to be telling them to the council.
I've already talked to Jefferson. Because he was in the vote. Okay. When I talked to Lou and Laura, they said, right after the hearing, they said, I said, why don't you keep your mouth shut?
This is blowing up.
I said, we did not have the votes.
He's going to live there. He's going to build
Jefferson, I did.
Yeah,
because they can't talk to Jefferson together. But
So you and I need to talk.
that's why
That's
I'm asking to extend this so that we can know that.
Right? I think that's what I'm
do you think we have Steve?
Pardon?
Do you think we have Steve Gearing or just two dates?
Oh, I don't think you have Gearing.
Yeah, I don't think I'll ever build a lot through my construction.
I don't think you have Gearing.
Really?
You know you
I
don't.
want to take the mill vote because I'm appealing with their money.
And then we're in a year.
6 months from now. Why don't I wait for 2 more weeks and listen to what the spirit of this conversation is going to be? Because I got a damn good example right now that I can bring up.
I think what we press is that projects that have been in the works for over a year
Her grandfather.
are grandfathered, and we push that with these 3 folks that I just mentioned.
Exactly.
Okay, and then push what we're doing for the rest of Malibu to get their support.
Is this on? It's all right then.
Is it on? Hello there. Oh, it is on. Jesus. We need to turn that off.
Trevor, Bonnie, you guys ready? Okay, then we're back in session with our August 7th meeting, and hi, Doug.
Hi. We consulted with our client, and we would like to ask for an extension to the first hearing in September, if we could.
Can I ask Bonnie a question?
Bonnie?
The council meeting's on August 28th, is that right?
Yes.
And our meeting would be on like the 7th?
The first meeting is September 5th.
Okay.
So,
is that enough time for you to get your act together for this hearing?
If you ask me, from where I'm sitting, I think we have our act together.
No, I mean for this particular issue.
Well, the item, not necessarily. I mean, it doesn't give us the full 10 days to get, we could bring it forth just exactly as it is presented today, but it would be difficult to provide any alternative analysis if that's what comes up.
Why don't we schedule it for the 5th, and it becomes clear to all of us that we should bump it. Can we bump it?
Sure. Okay. And
I just want to remind you too, and I actually kind of forgot tonight, but it wasn't a big deal because there's not a lot of items, that, and I would like you to remind me, I want to bring it first because you're coming back. I want to, before consent, everything. That would be on this item what I want to do with any item that gets
Yeah, our point is that on the 28th, a lot's going to be discussed, the spirit of some interest things, and we'll have a fact to make a presentation at that time to the city council. And so they'll hear this as a case of what's happening in this community and how it's being affected. So that alone will be a strong point that I feel will be a good thing.
If the council comes up with some new scheme, will you have time to do your neighborhood analysis and all that if they say so and get it in a staff report?
Like Chair Pearson said, we'll have to just see what comes out of the 28th. And as Commissioner Jennings said, it may not be as definitive as everybody hopes. It would be nice if it were, but it's a complicated topic.
Either way, we'd like to ask for the first.
Okay.
You know, just one last thought. The council, like it or not, the council created this problem for us. I think the best way to solve it is to either pass or not pass each project that comes up and sends it up to the council, because the council can then deal with it on case-by-case basis, and maybe we'll get some judge-made law in a way, that way. I mean, we'll get to understand what the parameters of their thinking is. I think that's going to be a lot easier than actually hoping that they're going to come up with a change in the law, which is really not a one-day deal. That's something that takes place over months and months. So, but that's just my.
Okay, well, I'd like to make a motion to continue the item to September 1st, 2017. 5th, 2017.
I will second the motion. Can we have a roll call, please?
Commissioner Mazza?
Yes.
Chair Pearson?
Yes.
Commissioner Jennings? Commissioner Euring?
Yes.
Vice Chair Marks?
Yes.
Motion carries.
Okay, we're moving on to item 5A, Coastal Development Permit number 17-064, Site Plan Review number 17-028, and Demolition Permit number 17-021, an application for the demolition of an existing two-story single-family residence and accessory structures and construction of a new single-family residence and associated development located at 33834 Pacific Coast Highway within the appealable coastal zone. Can we have a report, please?
Good evening, Chair Pearson and members of the Planning Commission.
Lily, before you get started, I just wanted to make one comment. There was a supplemental agenda report distributed for this item, and that was as a result of some email questions that came from commissioners. I have here for review, if anybody is interested, as part of the record, that email discussion.
Give it to Kathleen.
And I will be giving it to Kathleen.
We usually get our warnings from the city attorney about how we should avoid this practice in order to avoid violations of the Brown Act. You want to give us your routine warning?
Yes, it's important that outside of that all decisions are made here at the hearing, and that any discussions or items that we are up for discussion are discussed here at the hearing, not over email or in any other forum outside of here, particularly if there is a majority of the Planning Commission on such correspondence.
Okay, wait, so I just want to make sure I understand that. You're saying that there was discussion going on about an outcome to this previously for this item? Or I'm sorry, I didn't quite understand what you said.
It was, there was an inadvertent distribution of a response that went to more commissioners than it was intended to. And so we're just making that public so that it's all on the record, and if there's any question about what information has been shared or any of that stuff, that it's available. And it was covered all in the supplemental agenda report, but I just want to make sure that everybody knows that we have the email in the record too, just to cover all the bases.
Okay, can we have the report first?
This is on this item,
Yes.
Yeah, but Trevor, in the past, and this is years ago, I used to email the staff and ask them a question. Okay, they'd give me an answer. I'd now have information that the other people didn't have. And so once I replied all and I got slapped big. How are the other commissioners supposed to know what your answer was? Can the staff take that same email answer and the staff sends it to the other commissioners? Or is it just my own private knowledge?
The best practice is either that a supplemental report come out as it did here, sharing information with everyone, or that information is shared during the staff presentation before the hearing, and all that information will be made public to all the commissioners at the same time.
Okay, but one way or the other, it's presented to everybody.
Yes, but the point being that it's presented at the public hearing. There's no discussion going on outside of the public hearing.
Okay, can we have a report?
Just to add one tiny little thing, occasionally somebody will just ask a clarifying question like, is that lot vacant or not? Or was this square footage, or something like that? That's not really, it's just a clarification of a fact or something. Don't expect that to be distributed in a supplemental agenda report. I didn't want your expectations to be like that. You'll see extra agenda reports all over the place just because we've answered a question.
What's important is that any information that you're going to rely on in making your decision is disclosed at the public hearing. And that's why if you asked a question and it gave you information that is not in the public record, was not disclosed by staff, that you are going to rely on in making your decision, you need to disclose that during disclosure so that information is then made public and can be discussed and examined by the public if they disagree with the information you have or have a comment on that information.
Okay, thank you. A report, please.
The project before you tonight is a coastal development permit, site plan review, and demolition permit on a residentially developed property at 33834 Pacific Coast Highway. The subject property is a rectangular-shaped, bluff-top, 4-acre parcel in the rural residential 2-acre zoning district within the Appealable Coastal Zone. Surrounding properties are developed with 1- and 2-story single-family residences to the east, tennis and equestrian use to the north, and the Nicholas Canyon County Beach Park and the Wish-Toyo Foundation Chumash Discovery Village to the east. The project involves the construction of a single-family residence and attached garage, a 630 square foot second residential unit, and 889 cubic yards of non-exempt grading and associated development. A demolition permit is requested for the demolition of an existing 3,079 square foot 2-story single-family residence, a detached garage, and a driveway. An unpermitted spa and exterior stairway, as well as portions of concrete landings at the base of the bluff, would also be removed. The landings would not be removed in their entirety because doing so may result in slope failure. So portions of the landings would be removed to make them unusable, but ensure safety for the property owner. The proposed single-family residence is 9,712 square feet. The staff report and the resolution incorrectly states that this single-family residence is 10,342 square feet, which is actually the TDSF on the entire site, and that includes the 630 square foot second unit. A Phase 1 archaeological report demonstrated that the proposed improvements will have no adverse impacts on known cultural resources. The applicant is requesting a site plan review for construction of a residential dwelling up to 24 feet in height with a flat roof. Staff reviewed the project to determine whether the SPR would not adverse neighborhood character. The height of the proposed project at the top of the roof is 91 feet 6 inches, which is below the 112-foot elevation of PCH and existing development, and the installed story poles are not clearly visible from PCH. The proposed residence would overlap the existing development area and would be in the same location as the existing residence. Surrounding land uses are 1- and 2-story single-family residences on smaller lots to the east. There are no residential developments to the north and the west or the south. The subject parcel at 4 acres is larger than the surrounding residential properties, and as you can see from the aerial photo, the residential parcels to the east are smaller, but do appear to be developed with 2-story residences. Story poles were installed on the subject site to demonstrate the siding and massing of the residence and the second unit. This photo faces southwest, looking at the front of the residence. This is looking north, showing the western portion of the proposed residence. And this is facing west. This photo shows the project site from the Nicholas Canyon County Beach Park parking lot. As you can see, it is pretty difficult to see the story poles. This is the same photo zoomed in. The applicant proposes to reduce the required 100-foot bluff setback to 50 feet. Based on slope stability analysis provided by the applicant's geotechnical consultant, the city's geotechnical staff determined that the bluff is stable and meets city requirements. It was also determined that the average bluff retreat rate for a 100-year period would not exceed the 50-foot setback and is not expected to affect the stability of the proposed structure. Therefore, the setback reduction may be granted. Coastal imagery from 1972, 1981, and 2013 demonstrate that the slope has not eroded over time. For new development adjacent to parklands, where the purpose of the park is to protect the natural environment and ESHA, a 100-foot minimum natural vegetation buffer is required to minimize impacts to habitat and recreational opportunities. The 100-foot setback provision does not apply in this case, since the purpose of the beach park, specifically the eastern portion occupied by the Chumash Village, is not intended to protect the natural environment and ESHA, but instead to provide educational opportunities associated with the Chumash culture. A riparian area and creek are located on the project site, but it is an estimated 400 feet to the west of the subject property. ESHA development standards were not applied to the project because the vegetation that is being disturbed by the proposed development is located within field modification zones of the existing structure as well as neighboring structures. And with that, staff recommends that the Planning Commission adopt resolution number 1745, approving CDP 17-064, site plan review number 17-028, and demolition permit number 17-021. That concludes staff's presentation, and I'm available to answer any questions. Thank you.
Thank you very much. And as asked for disclosures, we got 2 letters in support that came in, so I'm going to pass them around so you can view them and pass them back when you're done so I can have Chris see them. Disclosures, none? Steve?
Commissioner Pearson and I visited the property, met with the architect, and got a real good perspective of what they're doing there. Didn't learn anything that really wasn't in the staff report.
I did not visit the property. I have known the two neighbors to the east for almost 56 years, and I visited that house hundreds of times. So I'm familiar with the area. That's it.
Commissioner Mazza, would your relationship with that family have any effect on your decision?
No. Well, I should also disclose, he's my next door neighbor in Hawaii also.
No disclosure.
But it does not affect my decision.
As Steve said, we met there with the architect, and then also actually there was who was the other guy? Neighbor?
The neighbor.
Was he the neighbor, a friend of a neighbor, somebody?
He was the neighbor and a friend of another neighbor.
Who was there, and they had apparently negotiated and were at some sort of understanding about their property line that made them both happy, which doesn't really enter this at all. Do we have any questions of staff?
A couple simple ones.
Why don't you go, John? You go.
On your landscape, I guess it's a landscape plan, it says, fuel modification plan, which is number 1, whatever that means. You show what looks like a hedge running all along the driveway, about 2/3 of the lot. Is that limited to 6 feet?
The city biologist placed a condition on the project to reduce the heights of any solid hedges to a maximum of 6 feet, view permeable per LIP standards.
Okay, and then on the slide from 1972, it showed some kind of structure on the beach. Is that still there? I guess it's a prior slide. Yeah, see, it looks like a little cabana or something down there. Is that?
Are you referring to, let's see.
Here, let me have a little pointer.
Yeah, it's just the landing.
This?
Yeah.
Here? This is the unpermitted landing that, a portion of which would be removed as part of this project.
But it's not enclosed by walls, correct?
It is not enclosed by walls.
And then the LIP section 10.4D has a big, long list of things that have to be done to prove the slope is stable, certified geologists and everything else. Has that been done?
Yes, it has. The city geotechnical staff reviewed the project. I spoke with him again this morning to confirm that the project does comply with all the standards.
That's it.
Chair?
Okay, Mr. Euring.
Could you put the picture up, the latest picture you had of the slope? Okay, I can barely see it from here, but, and okay. And I'm just trying, did you visit the site, Lily?
Yes, I did.
Okay. In this picture, along here is a stair, or a deck with a fence around it, right? And this is a solid platform. If you look at that today, okay, that fence is gone, that platform is broken up. Up here, the cement is buckling. There's a crack in the fence here, and this part of the walkway down here is also all crumbling up. Now, I'm not a expert in stuff moving or not moving or steady slopes or whatever, but someplace in the staff report it says nothing has changed since 1972. Now, something's changed since 2013. Now, again, I don't know if that means anything, if it's important. I would have expected when I read the staff report, if it says we visited and some of the stuff's crumbling, but it doesn't mean anything, then I sort of walk away saying, okay, somebody's got it covered. But when it's not mentioned and the other side is mentioned that says everything is stable, it just raises a question. I read these things. I mean, I do. I try and understand what they're saying, And I think the words are important. So if the words are in there, I believe you're saying what you're saying. And if that's the case, something's moving, for what it's worth.
Can I add to that a little bit?
Yeah.
Because John and I visited the property last time, when it got a previous CDP, and we went down there, and it was in bad disrepair then too. My opinion is, since then, the part of the path that's disintegrating, not that patio, has disintegrated a little more, but I don't see any land slippage. The question I would have would be on that deck, or I don't know, platform, I don't know what you call it. And maybe we can ask the applicant. I don't know if it's worse or not. I can't remember if it was taped off then. It wasn't in great shape at that time either, but I don't know if it's worse.
Yeah, and I can't, again, I can't tell you what caused the stuff to get cracked, so I don't know. It just, when I looked at it, it said, that's not what the staff report said. So that was the whole point.
If the concern is, are you concerned about the 50-foot setback or just the
well, the
discrepancy?
50-foot setback is based upon the stability of the bluff.
Right, so
And
yeah, so that's a different thing.
When I see the stuff moving, I'm saying, why is it moving?
And and so I think the distinction is the geologist is looking at the gross slope stability and from a more geotechnical standpoint and less from a superficial standpoint. So the superficial erosion that might be undermining the pathway and that deck are not the gross stability that he's looking at for.
If they would have said that in the report, I would have never had a question.
We'll keep that in mind.
I've got one other one. On page 11 of 24, there's a statement from a prior biologist, Holly Hill, whoever the heck she is. Well, there's no doubt to the value of maintaining bluff integrity to control erosion. It is unlikely that any effort to restore the natural condition would be supposed to say successful. So let me ask the question this way. If that sentence read the other way, if the sentence said, there is no doubt that if we try and restore some of the ESHA, we could be 99.9% successful, would that change any of the conclusions in your report?
I can't speak for the city biologist, but he did review the report and did agree with the biological assessment. The bluff is vegetated with invasive species such as ice plant, and I think that the small area, if restored, would not technically be defined as ESHA regardless, due to its small size and the fact that it is within the fuel modification of the existing residents and the neighboring residents.
I'm just wondering why that sentence is in there. If it doesn't mean anything, because I read it again and said, okay, they're saying that you can't restore ESHA. And I stand on my deck and I look down at Legacy Park and I got 20 acres of restored ESHA. So
I think that the issue with the bluff restoration is it gets difficult, increasingly difficult depending on how steep the bluff slope is. And I think that's probably part and how thoroughly, by the time you pull out a lot of invasives, I think then you make the slope unstable and things like that. So
yeah, I mean, the one takeaway, and that's I got one comment, and that's my last question. But I mean, when I looked at the slope of the bluff slope coming down, I mean, I would have thought it's got all ice plants sitting on there, which is like, shallow roots, heavy stuff. So I would have thought someplace in there in the biology report there would be a statement that says, boy, you guys should sort of plant some other stuff on the bluff to make sure but it wasn't in there, and they do what they want to do. I'm done.
I have actually one more question.
Oh, we do. John has a question.
Why doesn't this property have the fencing requirements that most properties have as far as permeability? It's next to a park. Across the street is mountains and stuff. Is there a reason why we allow them to fence it all the way around?
There is no fence proposed around the entire perimeter of the property.
So there wouldn't be, okay, so there wouldn't be a problem adding that condition. Okay.
Right.
Do you want to What, you're trying to fence the ocean side, or what are you talking about?
No, around the property, anything over a half an acre should be split rail. That's what we do with
If
everybody.
you'd like us to add that condition, we can add it, but they weren't proposing a perimeter fence, so we
Yeah,
didn't put it in.
no, that's what I'm gonna propose.
Oh, I see.
After the hearing, and they may tell me not to, but
Okay, can we open the hearing?
sure.
Okay. Public hearing is open. We have the applicant team, Steve Potter and Jeffrey Daniels. You have 15 minutes, and you can save it to rebuke from anyone you want, but doesn't look likely that you'll need that.
Okay, so my name's Steve Potter, and I am not the architect, but I did meet with Chairperson Pearson and Commissioner Uring. Jeff Daniels is the architect. He's here to give you a little bit of a presentation in just a minute. I'm a little confused about the concern about the perimeter fencing. We are proposing a 6-foot high wall on the east and west property lines for the portion outside the front yard setback and behind the bluff setback. The front will be no higher than 42 inches, and of course there'll be no fencing at all proposed from the bluff setback seaward or across, obviously, the seaward side of the property. So I think we would want some clarity regarding the split rail fencing before, as quickly as possible, because I don't quite understand what you're suggesting.
Do you want us to answer this?
Let us finish the,
Okay.
then we'll
And
get to that.
So the plans do state that we have the 2 walls, and then that's what we feel is beneficial to the neighbor, and it was part of the agreement that we would maintain that separation along the east, and on the west side, basically the Chumash Village and the egress from the beach is really a public right-of-way, and it is important to the client to maintain that that type of privacy. With respect to the condition of the improvements on the bluff, that flat area that is a little bit, we didn't go past a safety barricade, which is kind of thrown up there with 4x4s and some rope, which are intended to keep the Green family kids from walking onto this platform, and really didn't get the full feel for it when we did the tour. There's this flat area with a retaining wall in front of it. The flat area used to be about more than double its current size, and there was a washout due to a failure with a drainage device from PCH that caused a catastrophic event, and that thing has been there as long as I've known Mr. Green, and I met him in 1998. So I'll cede the rest of my time to Jeff Daniels, unless there's any other specific questions you have for me.
We'll get back to you with questions after this.
Good evening, Commissioners. Thank you for the opportunity. I just wanted to, I think it's already pretty clear in the plans, but I thought, this would be a way to just familiarize you with some of the design intent. If I press this, what advances the, not working. Oh, there we go. So this is the site. It's twisted now. It's shown in an east-west from left to right. Excuse me, north-south is left to right. But as you can see, the existing condition and the green lines indicate the setback lines, and I would call your attention to the curving one to the right of the screen. That's the southernmost part of that's the 50-foot setback line from the bluff. And as you can see, the existing house already encroaches into that, has been mentioned in the staff report, quite significantly. And that house is a 2-story house that goes up about 31 feet from the immediately adjacent grade. So the site is bordered, as has been noted, by PCH with the tennis and horseback riding club immediately on the other side of PCH. And to the east, there's single-family residences, and to the west, you can see the emergency egress road from the Nicholas Canyon County Park, and on the other side of that is the Chumash Village property. That is county-owned property and available, as far as we understand it, just by appointment only. The setback, as I've mentioned about the existing house, it's already encroaching into that, and the height, of course, goes above what is currently allowed. As has been mentioned, this application started out as a coastal development permit amendment to a design that was previously approved by the commission in 2012 in essentially the exact same position on the site. Oh, shoot. There we go. So this overlays the proposed house. The red part is the existing house. And you can see how we've pulled back and hugged the 50-foot setback line and essentially repaired the encroachment of the existing house. And the reason for this, by the way, you may be interested to know that the greens, the redesign is the result of the fact that the Green family has actually changed since the original approval. They've got more kids now, and they're more family kind of oriented, and they felt that the earlier design didn't quite provide the family-friendly aspects that they now need, and that's the main purpose for the redesign. And although an extension was granted for the amendment, unfortunately we had some delays that were brought about by a newly required on-site fire hydrant from our friends at the fire department, and so that caused some delays, and that allowed the permit to expire. So our main design goal in creating the new design was, first of all, as I mentioned, to completely respect the setback and repair that existing encroachment, to reduce the overall height from 31 feet to the allowable 24 feet, and to minimize the impact on any views from PCH by staying as far from the north, in other words, keeping the house as far south as it could be, so that the impact on PCH is as minimized as possible. We've also moved the intensive uses of the pool and spa, which before were facing directly onto the bluff, back to the northeast corner. I think you might see this better in this slide. Yeah. So this is just the new site plan, and the pool is now at the just northeast of the main house, which gives a more protected area for the kids to roam around in. And the guest house, the second residential unit was pulled away. In the previous design, it was incorporated as part of the main house, and it's now been pulled away and essentially backed up towards the tennis court as a separate structure. We've tried to create a design that is elegant, understated, and minimal. Well, this, again, as the planning staff report called out, the house, the highest part of the roof is over 20 feet below the grade elevation of PCH. So it's essentially invisible from PCH. And yeah, I won't walk you through the whole house plan, but we've tried to create something that is elegant and understated and minimal, even though it's a large home.
but we've tried to keep the visual impact as neutral as possible. It incorporates a number of sustainability strategies, including extensive cross ventilation, more than normal natural daylighting, green roofs, and photovoltaic solar panels on the roofs. It includes electrical battery backup for critical systems and state-of-the-art storm and wastewater treatment systems. So we feel that, and I think these are some shots of the elevations of the home, the proposed home. And this is on the north side as you come into the motor court, and this is a view from the bluff, the south side of the house. So it's a long horizontal home that tries to integrate itself into the natural landscape. And we believe that it not only meets all of the established planning criteria, but we hope it would be a structure that the city would actually feel a level of pride over having within its jurisdiction. Thank you very much.
Okay, thank you very much. Is there anyone else here that'd like to address? No. Okay. Seeing as there's no one, I am going to close the public hearing. And I'm back to the commission for discussion and/or a motion.
I have a staff question first. Bonnie, if we put in the required fencing provisions, and they had the split rail fence in the front, they could have the sidewall since it would be animal corridor, since there's no fence on the ocean side?
Well, the condition only applies if they're enclosing more than half an acre.
Yeah, and it's a 4-acre property.
Right.
So what I'm asking is, they could still have their side walls if they didn't enclose the front. Is that correct?
Yes.
Okay. I'm going to make a motion to approve
One other quick question, sorry.
Okay.
I just was noticing, the red picture and the green picture where they overlaid the old and the new. The old house was built in 51. Do we know what the setbacks were at that point? Were they 100 feet?
Doesn't matter. It's a demolition.
No. But my point is that an indicator of how much the slope
since
has
the
moved
home
in 51
I
years?
grew up on about a half mile away was hung over the cliff and was built in the 60s, I'm going to say there was no setback, just from personal knowledge.
All right, that's fair. I just because that would be another marker for movement.
Okay, I'm going to move the item as recommended with the addition of the standard fencing requirements.
Which requirements are we talking about?
Yeah, I want to have a question on that, because the whole front isn't fenced. So it's not enclosed, is it?
Well, that's if it's not enclosed, then it doesn't have. Then it would be wildlife permeable. If it's
Except
not
fish
enclosed,
don't walk.
If it's not enclosed, then it's not enclosing more than a half an acre, and that's what triggers the. It's actually, it says that it has to be visually permeable. There's a general plan policy that says perimeter fencing has to be permeable so as not to prohibit wildlife movement.
Right. So I'm just saying that it's a required
So as long as there's some way
condition.
out
If they
for
can meet
animals,
it, they can meet it.
It doesn't have to be entirely split rail or something.
No,
like
no,
that.
no.
There just has to be an egress
Just
point
either
somewhere.
the front or part of the side or something, so they can get in and out. But
Yeah, I just don't know how that rule works.
It's, well, I didn't,
but it's required.
Oh, I believe I just don't know what it is.
the policy I'm talking about perimeter fencing is in the general plan. Its implementation, it's in the conservation chapter, it's implementation policy 25.
It's also in the LIP, right?
No, not in the exact way that you're talking about.
Well, I'm just talking
The
about
LIP
our standard condition that's in everything
Well, that applies.
we ever approve. The only reason I'm saying this is the very most western house in all of Malibu, surrounded by park and open space, basically, except to the east.
There's a fencing condition or standard in the ESHA chapter, but this property's not ESHA, so that's not applicable. And then there's the standard, the general fencing policy for residential properties that I've mentioned, where it's enclosing more than half an acre, and that's a requirement for visual permeability, not
Right.
wildlife
Now,
permeability.
that brings up another question. It's mapped ESHA. So when does the city, now the city's determined it isn't ESHA, but it's mapped ESHA.
Right.
So when does the city correct that?
Where we have been tasked with updating the ESHA maps. So in this case, based on the site-specific biological assessment, this property would be remapped to reflect the
Right,
site-specific conclusions.
Okay, so
Can I just ask a question here? I want to understand the fence. So the whole front's open. So is it considered enclosed because there's fences around the other three sides? Or I want to make sure I understand it.
Well, and
Because I thought it had to be
don't know.
totally enclosed.
That's my understanding, because the issue is, if we're talking about the wildlife permeability issue, if there's a way to get out, then it's permeable.
but you got to get in first. The fish don't walk.
So does the fence
why we're
rule say
talking
there has
about
to be a
fish.
path of travel through the property? Is that how the rule reads? I just want to understand how
What's
it
that?
reads. Does the rule read that there has to be a path to travel through the property?
The policy says that perimeter fencing has to be permeable, this is from the general plan, has to be permeable so as not to prohibit wildlife movement. So there have been,
Oh.
you know, we'd have to establish that there's wildlife movement in question here, which, you know, it's not ESHA, so that's one question. Wildlife isn't limited to just ESHA, we all know that.
Right.
From the deer
So
at
it should,
Pepperdine.
it sounds like it should have that condition
If
then.
there, yeah, it could have that
Okay,
condition.
I'm just trying to understand how it was worded.
Do you have a second?
Just one question. Bonnie, one question. In the resolution, item number 24, it says, no exterior lighting is authorized under this approval. How does it, and I'm just trying to figure out, again, with hopefully this MLO coming at us in sometime in the future, what happens to this property vis-a-vis that agreement if and when it's, or that ordinance if and when it's passed?
Well, this project would be subject to the, whatever the compliance requirements are that end up in the ordinance. I mean, what we've talked about so far under the draft ordinance is a compliance period for residential projects. I forget where we left off, whether it was 3 years or 5 years. I think it started at 5 and maybe it turned into 3. And then more recently, the Planning Commission asked that we look at some options for projects that have been recently constructed and whether there should be an adjustment in the compliance period depending on what was installed and if it already meets the dark sky requirements or something similar to what we end up with in our ordinance. Maybe there's some leeway there so that people don't have to replace everything they just installed.
Okay, so in this case, he would come back later on with an exterior lighting plan?
And I was gonna ask you, which condition is that?
Condition 24.
Am I looking at the right?
I'm looking at the one that came out today.
Oh, okay. Let's see.
Well,
Condition 20,
so the way that reads, it would seem that when the MLO came in, they still couldn't have lights.
oh, that's actually the old resolution. That's Planning Commission Resolution 0508 from the previous project.
That's not the resolution that you're approving today.
So the current resolution has our standard lighting conditions that we put on every residential project.
Okay.
Okay, did anybody second it?
Can you make your motion again, please?
I move staff's recommendation with the addition of the standard fencing condition.
You want perimeter fencing to be wildlife permeable.
Yeah, the one we have in every, same language we use in
Well,
every one.
there's a fencing condition that we have for projects that are adjacent to ESHA or something like that, that it's required, the city biologist will put on that requires split rail fencing. But wildlife permeability can be achieved in a different way.
How do you do that?
We'd leave an opening somewhere.
Okay, as long as it's wildlife permeable, you've dealt with that before, that,
I think you did that on a recent project.
Sierra tree.
Yeah, we cut a hole in the fence every 50 feet, but we made that on the fly.
I'm going to ask the applicant, you have something you want to add?
The site plan clearly shows limitations and that I think provide a corridor in addition to the fact the entire bluff side, so the whole south property is open, no fencing, but 50 feet back up, the plans clearly state no wall or fence. That's a corridor. We're not enclosing.
Then the condition, if you don't have a fence, the condition will be moot. It's just a standard condition that is required
Right.
for animal corridors.
Right, so I believe that we have an animal corridor and that we should be allowed.
Yeah, so
to
if we pass this condition, you just work it out with the planning staff, show them that, and you're cool.
So you're saying the condition would have no impact on the
Not unless
site
you
plan?
threw up a fence all the way around it, you know?
No, but I guess what we would.
You can't do it. You can't put a fence all the way around it, or different rules apply.
Okay, this is something we do
Okay.
every project.
Okay.
You're clarifying that the fence doesn't go into the setback from the cliff, right? So that there'd be 50 feet of open.
It's clearly on the
Yeah.
plan.
Okay.
Oh, right, so the 50 feet on the front going,
Well, it's got to be more than that. It's got to be animal portable.
Plus 250 down the south property line.
Yeah.
So you've got a total of 350. So you have 50 feet from the bluff, plus the distance from the bluff to the mean high tide line, plus 250 across the south property line. So you've
Which is
got
below.
somewhere over 400 feet of unfenced area.
Yeah, so you're home free.
Perfect.
Not my opinion, but the staff can tell you that. Second?
Jeff?
God knows, I do not want to prolong this any longer than I have to. I just don't understand what the standard perimeter fencing condition is supposed to be. Is there one?
It's on every project we have.
It's on projects the city biologist identifies that are, I believe they're typically near ESHA, where you need, he requires split rail fencing or something similar.
I'll sec. Go ahead.
Okay, anything else? Can we vote? Kathleen, would you do a roll call, please?
Commissioner Mazza?
Yes.
Commissioner Euring?
Yes.
Commissioner Jennings? Yes. Vice Chair Marks?
Yes.
Chair Pearson?
Sure.
Motion carries.
Move we adjourn.
Second?
Second. Aye.